Thank you. You can be seated. Okay, let's go on the record then and file 22-5165-FH. Welcome back, everybody. Tuesday morning, we will, in the record, can reflect the jury is outside the courtroom. We'll obviously continue with Mr. Ralston's cross-examination of Mr. Null. Anything that we need to talk about before we get started with that? Do you, Mr. Ralston?
No, sir.
Mr. Null? No. Mr. Seibert?
No, thank you.
Mr. Barnett?
No, Your Honor.
Thank you. All rise for the jury. Okay, everyone can be seated. Welcome back, ladies and gentlemen. I hope everyone had a nice evening. We're in the cross-examination portion of the testimony for Mr. William Null. So, sir, if you want to go through this thing again. And if you want to bring anything or anything, sir.
I got it. Thank you.
Okay. After you raise your right hand, do you swear that the testimony you're about to provide will be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Go ahead and seat for me.
Thank you, Judge. Good morning. Mr. Null, when we left off yesterday, I think we went through some Facebook communication of yours. And I want to stop for a minute and ask a little bit about Phil Robinson. You said you're one of the founding members of your militia, correct?
Yes, sir.
Okay. And, like, what was your role in that group?
I don't know. We were the
You don't know your role? I'm sorry.
I was trying to explain it, sir. I don't know how to explain our militia group. We didn't have XOs or COs or anything. We were just a round table. The three of us were the men who started the group, and then if there was any discussion in the group, we would all do it, but ultimately the three of us would make the decision of the group.
Okay. You talked about Phil Robinson being a peacock. Remember that?
Yes, sir.
Okay, and what did you mean by that? Well, how was Mr. Robinson one of the leaders in your group of peacock?
Well, Mr. Robinson, we were at a rally. He would go right to the media. He loved to get his picture taken, and he strutted everywhere he went. So when we call him the peacock, that's what we named him, the peacock. That's why we named him the peacock.
Peacock is a bird of great beauty, correct?
I would agree. Yeah.
Yeah.
They're flashy.
And was Phil afraid to take action?
I don't know what you mean by that, sir.
Well, you seem to call him a peacock, and kind of you juxtapose that against yourself and your brother Mike, right?
I oppose that.
You use that to describe him as being different from yourself.
Oh yeah, like I said, he created media attention. I mean, we were on the media, but I didn't go right to him to say I'm Phil Robinson and I want an interview.
Mm-hmm. Okay.
That's why we named him Peacock, because he strutted his stuff all over.
You were more of the kind of hands-on person?
No, I didn't go and seek the media attention like he did.
Okay. Let's turn to a little different subject. You were arrested on October 7th, correct?
Yes, sir.
Treated fairly by those that arrested you. Would you agree?
I suppose so, yeah.
Okay. Once you're in custody, you were given your Miranda rights, correct?
Once I was at the casino, yes.
Right, and they took you to the tribal police department, is that correct?
I believe that's where, I believe that's where it was, yes. It was, we were at the casino. I assume that's what it was.
I guess my point is, I mean, for the jury's benefit, I mean, you agreed to talk to the investigators. Would that be a fair summary?
Yeah, I talked to him.
I mean, but I think they didn't make you talk to them, right?
No, but I talked to him, yes.
Okay, I mean, it was you talked to them voluntarily, is I guess what I'm trying to say.
Yeah, I would agree.
Okay, and I mean, they gave you some food and things to drink, you know, some pop or water, coffee, right?
I don't recall. I know I had a sandwich, and I'm sure they gave me water, yeah.
Okay, all right. Okay, going to play a couple of clips here for you.
Yes,
And
sir.
then I'll ask you some questions, okay?
Okay.
Proposed exhibit 288, please. And before you play that, Adam, you've listened to these, is that correct? The three clips?
Yes, I listened to him yesterday.
Right, and fair and accurate representations of what you told the investigators during your interview?
Yeah, I think so, yeah.
I mean, it represents the words you spoke accurately.
Yeah.
Okay, fair enough.
Mr. Olson, before you play, just so the jury's aware, ladies and gentlemen, because we had some discussion outside your presence, these clips were admitted over objection from the defense counsel. If you recall, the discussion we had, you've heard me say MRA 106, right, with the expanded clips, we've done that a couple of times. That was requested by Mr. Null for the clips that you're going to hear. So what we'll do is after the people play 288, for example, you'll hear defendant William Null's exhibit AA, which is the expanded clip, and then that's how we'll rotate again, as you heard. Once the people play a clip, then we'll play the requested one from Mr. Null. Okay. All right, Mr. Wilson, go ahead.
Thank you, Judge.
So the best of your ability, show me, to explain to me how that conversation went. Because what you're saying, we're having a good day training, we're doing what we normally do, and then I'm approached and told that we're going to do this program. Tell me how that went down.
Well, we were doing trainings, and then we got called aside and asked if we wanted to come on a recon mission.
Who's we?
Well, I was, but Mike actually wasn't there. He was up training with the kids.
Okay.
I asked Mike literally if he wanted to go with me when he died.
So how was this reconnaissance mission planned? Or how was it presented? How was it presented to you?
Basically, if we wanted to go up for a ride up towards there, and then they had told me that it was the governor's house.
Okay.
And you all have AA as well.
Judge, we didn't know that.
That's okay.
Right this morning. Sorry,
You're fine.
technical difficulties.
Well, we were doing trainings, and then we got called aside to ask if we wanted to go on a recon mission.
Who's we?
Well, I was. Mike actually wasn't there. He was up training with the kids.
Okay.
I asked Mike literally if he wanted to go with me when we left.
So how was this reconnaissance mission planned? Or how was it presented? How was it presented to you?
Basically, if we wanted to go up for a ride up towards there, and then they had told me that it was the governor's house.
Okay.
So, and again, I just never went down towards her house. I don't know. We followed along in this car. We sat, and we basically sat in this car. That's what we did in the third car. The other two cars drove around, but I don't exactly know what they did.
Fair portrayal of what you told the investigators October 7th of 2020, right?
Yes, sir.
Okay. Can I have 289, please?
Mike was, I literally asked Mike if he wanted to
ride with us. He wasn't there for that situation. I'm telling you right now, he was not even in there. He went for the ride with us, yes.
Okay.
He was not in that. He wasn't in that briefing or whatever.
That where they came out, where Adam clearly said, this is what our plan is, this is what we're gonna do.
Like I said, I was told we're gonna go scout past this house, the governor's mansion, yes, or the governor's house, whatever. And they were gonna do a recon or drive past it.
So I want to clear something up then, because you're telling me that at no point in any meeting, any training scenario, this reconnaissance mission, or even the next reconnaissance one that you met with, at no point someone said, we have a plan that we're working on to kidnap or kill the governor of Michigan. No one ever made that clear to you? Because if not, we're gonna have to clear something up here.
No, there, like I say, there was a talk about going after the governor, yes. That, like I say, and then we went on a drive.
Okay.
So, yes, it was at that meeting there, whatever, we were there.
Okay.
And corresponding defendant William Null's BB.
Mike, but I literally asked Mike if he wanted to ride with us. He wasn't there for that situation. I'm telling you right now, he was not even in there. He went for the ride with us, yes.
Okay.
He was not in that. He wasn't in that briefing or whatever.
That where they came out, where Adam clearly said, this is what our plan is, this is what we're gonna do.
Like I said, I was told we're gonna go scout past this house, the governor's mansion, yes, or the governor's house, whatever. And they were gonna do a recon visit or drive past it.
So I want to clear something up then, because you're telling me that at no point in any meeting, any training scenario, this reconnaissance mission, or even the next reconnaissance one that you might want, at no point someone said, we have a plan that we're working on to kidnap or kill the governor of Michigan. No one ever made that clear to you? Because if not, we're going to have to clear something up here.
No, there, like I said, there was a talk about going after the governor, yes. That, like I say, and then we went on a drive.
Okay.
So yes, it was at that meeting there, whatever, when we were there.
Okay.
You know, I've networked with several groups and against Mike, but the shit goes out there, so you never know
How legit
how
your
legit
position
it
is.
is.
Okay.
So,
Okay. No, I appreciate that.
Just so we all heard, do we hear correctly that you said talk about going after the governor and then we went on the ride? Is that correct?
That's what I had said, yes.
Okay. Can I have 290, please?
At one point that you can remember, did Adam sit down with you and say, okay, here's what the plan is. We're going to eventually either go to the capital of Michigan, or we're going to go to a residence or somewhere else. We're going to kidnap the governor of Michigan, and we're going to take her away by force. I think, I want you to think, before you answer that, just take your time with that, because I don't want to have to undo things for you. I would rather have the truth. And then we can talk later about how serious you thought it was or what your level of participation is. But it sounded the first time that he had that conversation with you that you remember.
Probably at the one in Cadillac.
Okay.
And corresponding defendant William Null's exhibit CC.
At what point that you can remember did Adam sit down with you and say, okay, here's what the plan is. We're going to eventually either go to the capital of Michigan, or we're going to go to a residence or somewhere else. We're going to kidnap the governor of Michigan, and we're going to take her away by force. I want you to think, before you answer that, just take your time with that because I don't want to have to undo things for you. I would rather have the truth. And then we can talk later about how serious you thought it was or what your level of participation is. But tell me the first time that he had that conversation with you that you remember.
Probably at the one in Cadillac.
Okay. So it was that time when you went up there, you did the training, and then they said, we're going to go on this reconnaissance mission. Okay. Do you kind of tell me in your words, how did he present that to you? Was it to the whole group, or did...
He just asked us if we wanted to go for a ride. And so we went for a ride. That's exactly how it happened. I didn't spend a lot of time with Adam. I spent a lot of time, like I said, I spent a lot of time at a training thing there. Adam was there half the time.
Okay. And
Yeah, no problem.
Thank you.
Not at all. Thank you. Judge, I don't know if I moved. If I didn't, I'd move for admission of 288, 289, 290, please.
And then 288, 289, 290 will be admitted, subject to the discussion we had certainly. And then along with that, A, defendant William Null's AA, BD, and CC are also.
Mr. Null, in Exhibit 290, the last one we just played there, you talked about, kind of when Adam shared that with you, and you said at the one in Cadillac, correct?
Yes, sir.
Okay, when you said at the one in Cadillac, are you talking about the Luther FTX?
I would have to guess. I don't know if I'm talking about the car ride or Luther. It was long ago. I said Cadillac, but.
Okay. I mean, those were your words, right?
Yes, sir.
I mean, can you tell the jury whether or not you were talking about Luther or Cadillac?
I don't know if I'm talking about when we're in the car at Cadillac or Luther, but we were at the training in Luther and then we went to Cadillac. There was several discussions there. I don't know whether I'm not exactly talking about Luther. I'm assuming we're at Luther, but again, it was Cadillac. Adam did ask me to go for a ride in Luther, but he talked about it in Cadillac. So
Talk about both places.
yes, once I was already in the car.
And in 289, you said that you talked about, they talked about going after the governor and then we went for the ride. Do you remember that?
Yes, I do.
Okay, so you knew what it was about before you got in the vehicle.
Yes, but again, I didn't know how serious these people were. You can see that we've talked about it, yes, but again, when you're in these group settings, people talk some crazy shit sometimes, and you don't know how serious these people really are.
Mr. Null, that exceeded the question at this time.
Sorry,
No,
sir.
that's okay. Your attorney will have a chance to call the redirect, so he can ask any follow-up questions if he
Yes, sir.
wishes to.
Thank you, Judge. Okay, you went to Dublin, right?
Yes, I did.
Okay, did you spend the night there?
No, I did not.
Okay. The distance from Dublin to your home, I mean, you're a working man, right?
Yes, sir.
Okay, you take the day off work, you don't get paid, right?
I don't remember if lockdowns were. I don't know if lockdowns were in place yet or not, and I don't know exactly my work schedule. So to be honest, I don't know. I probably took the day off, but we were in the lockdowns, so I don't know how to clearly answer that question.
Okay, I think the question was, if you don't work, you don't get paid.
Yes.
Fair summary?
Yep.
Okay. Tell the ladies and gentlemen of the jury how far you drove to get to Dublin.
4.5 hours, if my memory serves me. I believe it was about 4.5 hours.
Sure.
It could have been
And
5.
this is part of your networking that you told us about, correct?
Yes, sir.
Part of networking with other militias across the country, right?
Yes, sir.
Okay. Okay, let's talk about Dublin a little bit. Can I have Exhibit 57, please, on the transcript? I'm going to play a couple of clips here for you, and I'll ask you a couple of questions, okay?
Yes, sir.
So
know that you have to take action, there are levels of action, sharing the information, utilizing all those tools. I'm gonna go hurt people. I'm gonna go hurt people in their fucking bed, and I apologize. I'm sorry. I'm gonna burn motherfuckers' houses down and blow shit up. I'm gonna do some of those nasty, disgusting things that you have ever read about. And it gets straight, you like, I like it. Now listen, and I'm sorry for that. I really am. Well, no, because it's wrong. Because when a commandment I was commanded, and I have to break that father's why. I've already asked permission. It's been granted. I'm not worried about it anymore. I'm not even gonna give it a second thought. If I fly through a motherfucker, burn his whole motherfucking family to the ground, knowing that I have one myself, I'm sorry. But I'm gonna do it.
That was Mr. Croft at the meeting, correct?
Yes, sir.
And you were there, right?
Yes, sir.
Adam Fox was there?
Yes, sir.
Okay. Why can't I keep you?
Without the people, without the lowest of the low, there's no reason for us to do it. You know what I mean? Now, it pisses me off. I drive by these people that are out there stomping around and filth, signs on people driving by them for lying. Got empty houses out here that banks. Listen, I'll go to your bank and I'll strip your employees, but motherfucking need you, and I'll be great and dressed like the fucking FBI. You think I'm fucking lying? Test me. Fuck around and find out. You can really fuck around and find out. I'll cut my own fucking sheets so you put a straw on me that your fucking facial recognition is not understanding you picked up, and I'll cover everything but that straw. I'll become a new motherfucker right before your eyes. I'll redefine myself as necessary. But I'm getting ready to go kick loose with fucking animals like myself. Now, you're gonna need to publicize these things. I'm gonna be stupid shit. I might murder a cop, drag his fucking uniform, 31, and go murder a vet just to get them places within themselves. I want them to no, I'm not being like that. Well, I'm being fucking serious like the hard back ticket I want. You know, the thing of it is, they've been doing this to me instead. They've been dressing like me and you going out and cursing people. And I'm going to do the same fucking thing. You wrote the Pandora's box. You opened up all the weapons that are in that kingdom. Okay? I would have never had the time to this weapon if you didn't try to overtake my own first. This fight started in heaven, gentlemen. We're just getting ready to go rehash it for another time on earth. It's happened thousands of times. There's anything under the sun. And giants at my gate before, not worried about it. I'm ready to fuck them up. And I'm gonna hurt you bad. I'm gonna terrorize. You want a terrorist? You labeled me a terrorist. I'm gonna go be what I need. I'm gonna go be what I need. You're all terrorists.
You're in the room when that happened, right?
Yes, I am. Several other people?
This is June 6th, correct?
Yes.
Okay. And obviously before your nighttime surveillance, correct?
Yes, sir.
Okay. Can I have 59, please?
I'm going to be here soon. I have very little time left before they come to the fuck up in the middle. I do not intend to go out like that. So I'm telling my boss Monday when I get back, you need to be next week. How long? You can fucking have a funeral or everything with that game. And I'm going to leave. And I'm going to get into the field. And I'm going to start operating. And I guarantee you that motherfuckers are going to join up at my flanks because they're going to love the shit that I'm getting ready to do. I'm going to get rid of 11 buildings, burn motherfuckers' houses down with every side of it, and I'm getting ready to fucking put it there so you can all see it. Listen, I'm like terrorized when they terrorize people. I'm going to go terrorize the right people, the people that have been terrorizing my people. So you got a state police officer fucking marked out their shit. Probably gonna hose your shit down with fucking sprayers in the night set your shit on fire, and record you screaming and you can't fucking leave. You should have had the people like, listen, man, sorry, you chose to be on the wrong side, which is my bad. And look, and when I do that, I'm gonna have foot rats coming out. I'm gonna have people that aren't operators coming out. They're gonna press their fucking luck into nature, taking these baggies out for you. You ain't even gonna have to train them, Steve. And natural progression and the wrath that they have inspired in it is gonna take care of it. I'm just gonna fucking show you how to do it with fucking instructional videos that they can't do the fuck out.
60, please.
Your Honor, was there a question relative to that last exhibit, or?
After I get done with these exhibits, I'll be questioning him about them.
Okay, thank you. Sure.
I think a lot of their ideas are better there. I think we need to take this and talk and turn into action. I think the most important thing for us right now is to keep that negative media print. When we go to county with arms, when we get our fucking house to listen to us, and both the end stable order, then we have a principal governor. So I'm do that, and not out of the check bill, the our state government. But yeah, we're calling that the fucking terrorists. Not one violent fucking thing happened in that day. Not one violent thing happened with the multiple rallies we had in our capital, okay? That's another thing I think is, I think the rallies is fucking really been turned over. To be honest, in my opinion, it's really sad. They need to get out. Yeah, there's so many people that on the internet, we got, they can't make a trip to the Capitol for that.
I personally disagree with Michigan set the tone.
We did, we went out to the house, all in that big, we went there, we took what we had, and we let our country go, we fucking stopped our feet, we shook fucking all that kind
Hey, I'd like to say there's one thing real quick. We should not go to a rally if we don't have control, if we don't have, the manpower. 10
Right there, we were affected that day. Our house first, they voted in our favor. They were not going to get that, that's what we think. We got right out, we got right, where she lived at.
I know,
I have a solicited my state, I have over 200 members, that we can't get more than a handful of their members, so our requirements. Israel listens to every fucking thing. Hold out about every fucking one, and only was already in cost, my favorite, I was doing what they want to see out their asses. You know, this is fucking crazy, so I got listening right about how they have 200 fucking men to get kicked over a handful of people there. And they had 5 cartloads of people battle ready in Grand Rapids, and they fucking burned out. They went out and drove around for less than an hour. By the time they burned out, they were leaving to go home because they were down already. What happened to them, CPL and shit. I had to walk the fucking park your ass, get the fuck out of the period. But no, it was all fucking 25 days. By the time I got to Grand Rapids, and they're fucking leaving. Not even 25 minutes later, our fucking city's burned down. But they got their fucking pictures, they got their photo going down. They fucking were Grand Rapids were down, yeah, no, to the point that they fucking were coming down.
Hey, Mr. Null, how long does this meeting last?
Oh, probably 2 hours was the actual meeting, if I remember correctly.
Okay. And why'd you go?
I was networking. You've seen the text messages. I was networking from Facebook networking.
Okay, I mean, anybody talk about handing out water or helping the underprivileged or doing any charitable events? I mean, was there any of that part of the discussion during the 2 hours?
There were several discussions there. There was 20 people talked.
No, my question was, did anybody talk about doing charitable acts like you described your group apparently did?
My group did. There was, like I said, there were several people talking there. I don't recall all the statements there.
Would you agree with me that there was no statements about helping the underprivileged?
I don't recall everything that was said there. I don't remember talking about doing a Flint water drive, no.
Okay, in terms of what you do recall, I mean, do you remember any discussion about, wow, you know, we ought to go down? Dublin is a suburb of Columbus, correct?
Yes, sir.
And you've driven there 4.5 hours, right?
Yes, sir.
Okay. I mean, is there any discussion about going, you know, down into Columbus and helping out the underprivileged or doing anything charitable?
No, I'm not. Like I said, I don't recall any conversation like that.
Okay, okay. In Exhibit 58, there's a discussion, there's a gentleman there that says, you know, fuck around, find out. What does that mean to you?
I don't know. Just, yeah, fuck around with him and find out, I guess. I don't know how to answer that.
You don't know what that means?
I don't know what's going on in his head.
Oh, no, I didn't ask that. What's that term mean to you?
I don't know. Fuck around and find out.
It's a warning, isn't it?
You can take it at that, yeah.
I mean, it's a warning to another person. Fuck around with me and you'll find out, right?
Okay.
No, you agree with that?
Yeah.
Okay, now you said you went down there to network, right?
Yes, I did.
Okay. When you came away, I mean, networking by definition, would you agree? It means you're going to go to a place, you're going to network with other people, and you're going to come away with their names and their telephone numbers and how to reach them, right? And, you know, how to work together in the future. Would you agree?
Yeah, that's a point of networking.
Okay. Whose name did you come away with? Whose names did you come away with and their contact information from Dublin?
I think the entire group. Jenny Plunk took a piece of paper and had everybody write their names down in that, and I don't know, I don't remember who signed it and who did what.
Oh, no, that didn't answer my question. I mean, I asked, who did you come away with? What contacts did Bill Null have when he came away from the Dublin New Founding Fathers?
Well, I know that I came away with Steve Robeson's, Jenny Plunk.
Okay, you're naming off all the federal agents now, right? I'll withdraw. I'll withdraw.
That question will be withdrawn.
Okay.
This is still answering the previous question. Mr. Null, if you can recall, the name and contact information, not that information that the individuals received after or at that meeting.
Yes, sir. Like I said, Steve Robeson, Jenny Plunk, Jeremy Dieter, I think Barry Croft wrote his number down. Adam Fox. There is a guy from Virginia. I think his name was Butler. I know that there was a guy from the West Ohio Minutemen, plus Brian Hennon was there. Like I said, there's a bunch of people there. They wrote numbers down. So I had whoever wrote their number down, that's the contact information that I had.
So you came away with the list?
I did.
The sign-in list?
I don't remember. I don't think I got the list. There was numbers. We had to take them down. I don't remember how they distributed the numbers.
Well, how are you going to contact these people when you got back to Michigan is really the question. 'Cause
I,
you're networking, right?
yes, sir.
Go ahead.
They were wrote down. Again, I don't remember. I know there was a new founding fathers thing set up. I don't know if that's where the list came from or how we got contacts, but I had a few phone numbers, yes. But there was a list given to Jenny Plunk, and it was her or Brian Hennon. I think Brian Hennon started the new founding fathers chat. I don't recall who all's in that either. Nobody ever really used the chat.
I mean, would you be correct to say that the people that were in Dublin were talking about attacking their governors in multiple states at the same time?
I don't recall that being said. I know that Barry ranted about some crazy shit. Again, there was a lot of conversations going on there, and there was a lot of pissed off people about what was going on in this country.
Mm-hmm. You keep saying about what was going on in the country. What was going on in the country June 6th?
June 6th?
Yeah.
That night, Columbus got attacked by a riot. There was riots all over this country.
Okay. And
Before that, there was riots all over this country. You hear them talking about more riots going on all over this country.
you didn't like the COVID restrictions, did you? You talked about it yesterday that you tried to get breakfast and couldn't because you didn't have a mask, right?
Yeah, I was not a big fan of COVID.
Speak up, I didn't get everyone around a hard time.
No, no problem. You didn't like the COVID restrictions, right? You were mad at the governor about that.
Yeah, I did not like the COVID restrictions. I don't know who liked them.
It's kind of like the land you talked about. You know, you want to do what you want on your own land, and you don't want anybody to tell you what to do, right?
No, and that's why I argue that in court.
I mean, that's, you feel that way, right?
Yeah.
You don't like people telling you what to do you, from government?
Well, within reason, there's certain rules that I definitely apply to,
Mm-hmm.
but yeah, when you have your property rights, stuff like that, that's your land. I
Okay.
agree that I don't like being told what I can and cannot do on my own land.
Okay, earlier I asked you, the basic conversation in Dublin was about, there were people from what, 7 or 8 states there?
I would assume, yes, there was multiple states there.
And you remember at the beginning of the meeting, everybody went around and said where they were from, right?
Yes, I remember that
You said, I'm
conversation.
Bill Null, I'm from Michigan.
Yes, sir.
Okay, Adam Fox is there, he said he was from Michigan too, right?
Yes, sir.
Okay, and you said you didn't recall if the conversation was about a simultaneous attack on governors in different states. I mean, isn't that something that would stick out in your mind?
It depends on what the conversation was. There was, like I said, there were some people ranting about some crazy shit. Yes, I absolutely agree with that.
Okay. I mean, in your mind, what was the purpose of going for the meeting in Dublin? Tell the ladies and gentlemen on the jury. What was the reason you drove 9 hours that day there and back to attend this meeting?
Again, networking with groups. I think we already talked about this, but I was networking with groups from Facebook that we had talked about from a specific Facebook page. That's how I got the invite down there. When I went there, I have no idea what the rest of the world's going to be talking about. I don't know all these people personally. I actually only knew 2 people at that meeting before I got there. So again, I'm introduced to a group of people I don't know, and I went to that meeting for networking.
Okay. Can I have 62, please? This is another clip from the meeting.
I remember here, well, I don't know if you were there on the day we went to the Capitol. I'm telling you, we went to the Capitol. Yeah, I went in there and I talked to the rally to go to the Capitol. I haven't across the country. Every fucking place locked out their Capitol. We're not going to those fucking the first I joined. So I'm telling you, we made a plan. We need to make an effort. You have to get we got to communicate out because you'll see in Michigan, most of our fucking communications in Michigan is fucking Facebook or somebody's fucking telephone. Yeah. Every one of them are compromising their fucking phones. And that one, I don't know, there must be 15 list groups in there, we do other similar all the time. Yes.
Hey, Mr. Null, up there when you're talking about the plan, or if we make a plan, we need to make a network. What did you mean by that?
If we make a plan, I'm talking about getting communications down. If we have a plan, if shit hits the fan, we have to have communications down. We need to know if we have people around us that can help us. We don't know at this point in time, again, we don't know what's going to happen. You're in lockdowns, you got riots. And it was communications. We wanted to get to know and know if we had people to help us in a bad situation.
Okay. In terms of, you said you have to we've got to get our communications down. Are you talking about for the Boogaloo?
No, I'm talking about if shit hits the fan. I don't know what's going on in the country. There again, riots. There's people being killed in the streets. The cops are standing down. That's what drove the people to go to this meeting.
Okay. Tell the ladies and gentlemen where you lived back then.
Where I lived?
Yeah.
Yeah, I lived in Berry County at this time.
Okay, and tell them the kind of the setting that you lived in. And you live right in town, or in a community, or were you out in the country?
It's kind of out in the country. It's a little small town just like Anson County.
Okay, and were there riots in Berry County that you were worried about?
We actually had a protest. They said they were coming to your community, and they showed up in Hastings.
Okay, and how far is Hastings from where you live?
Probably 15 minutes.
And that's a monument. They were going to protest a monument there. Is that right?
Yeah, they were protesting a monument, talking about tearing it down.
Okay. And, I mean, it was a protest, it wasn't a riot, right?
No, because the entire community showed up there. There must have.
Well, no, I'm gonna object to that answer. It's non-responsive.
Gentlemen,
I'm objecting non-responsive.
I,
hang on, no, Mr. Null.
sorry.
I'm gonna use both hands. We're gonna bring it down. Okay? Here it is, Tuesday of week 4. Mr. Ralston, the question again. Mr. Null, and again, and I don't say this critically, sir, I understand it's a normal phrase of speech. You hear me say normal people all the time, right?
Yes, sir.
We're lawyers, we're not.
Okay.
And so, but Mr. Nunzio will certainly have another opportunity to ask you questions. So if there's something to be expounded upon, he can do that with you. So if you could just make sure that you're answering the question that was asked. Okay.
Yes, sir. I will.
Mr.
Try.
Ralston.
And without telling us about what the community felt, I mean, what I'm asking you about is, what happened in Hastings that day wasn't a riot. Would you agree?
Yes, it did. It didn't turn into a riot.
Okay. And, I mean, there's nothing going on in your community really that you're too worried about. Would that be a fair summary?
In my community.
Meaning Berry County, you got Dar Leaf there looking out for you, right?
Yeah, well, he can only do so much, but yes.
Sure. Okay. You talked about in this exhibit, you talked about all we have is fucking Facebook and somebody's fucking telephone. What's wrong with Facebook?
Yeah, Facebook it's Fedbook. I don't know how else to explain that.
Okay. What's wrong with a cell phone? I mean, communicating like that.
Well, we still do. I mean, we communicated on it, but I figure everybody's listening and they're tracking you on your cell phone.
You practice operational security, didn't you?
I don't know how to answer that. I always had my cell phone with me. I mean, do I practice it? There's certain times where I would leave my phone away. Yeah.
Okay. And going back to, can I have exhibit 60, please, back up? And second page at the bottom. Go back up, Adam. I'm sorry, right there. Yeah. Hey, you know who Amanda Keller is, right?
Yes, I've met her a couple times.
Okay. And I'm sorry. Go on down, Adam. Bottom of the second page. I'm sorry. Okay, you're in the room with her, right? When she's talking.
Yes, yeah.
This is June 6th, right? 2020?
Yeah.
And Amanda Keller says, I know where her summer house is. I mean, you heard, as early as June 6th, the idea of the governor's summer house as being possible target. Fair summer?
No, I wouldn't agree with that. There was a lot of talking going on and people were yelling and that. I can't say that I actually heard any of that.
Okay, kind of like when you went to the bathroom at the AMVets, maybe you missed that part of the conversation, right?
Quite possibly.
Objection, Judge, argumentative.
I don't think it is. And not only that, it's not his witness.
Hang on. I'm going to overrule the objection because I don't think the question in itself was argumentative. I think perhaps the way in which it was asked, there was a little bit of flair behind it. So if we could ask the question again,
Sure.
we'll try that.
Okay. So maybe you missed that part of the conversation, kind of like you missed the conversation at the AMVets when you were urinating there in the night.
Objection, compound question. Requesting one response for two questions.
Well, he's not requesting a second answer for that question. He's referencing a question that he was asked, or a series of questions that he was asked on direct examination, which is why I told him a lot of questions. So go ahead.
Thank you. So it's kind of like what you told the jury yesterday, that you couldn't hear what was going on at the vehicles in the AMVets because you were urinating, right? Maybe you missed that part of the conversation. Is it kind of the same thing?
Well, it's two different situations, but yes.
Okay. Mike know you were going to Dublin?
Did he know I was going to Dublin? Yeah, I think he knows that I went to Dublin, yeah.
Okay, what,
The relevant judge, this has nothing to do with the charges.
thank you. How did he know?
I probably told him that I was going to Dublin.
Okay, and you're not sure?
I would assume that I told him that I went to Dublin. That was many years ago.
Okay, then I'm gonna try to refresh your memory with the document. Before I do that, I'm gonna show you something that's gonna work for identification purposes right now is 302. Okay. Do me a favor, Mr. Null, I know the print's a little small. Maybe we can turn the lights up a little bit too, and take a look at those pages and read those. Let me know when you're done, if you would, please.
Did you have a chance to review this?
Oh, yes, I did.
Okay, does that help to refresh your memory as to whether or not you told Mike about going to Dublin?
Yeah, like I said, I must have told him.
Okay, and he checked on you while you were down there, is that correct?
Yes, sir.
Okay, and he said, he warned you to be careful about suspicious shit, right?
Yeah, because I don't know these people that I'm going to meet, so he's probably concerned about me, yeah.
Okay, all right. I mean, is that part of networking?
I didn't hear the question.
Is that part of networking?
Yeah, you meet new people that you don't know. I mean,
Okay. I mean, why is your networking, I mean, why would you network with suspicious people, I guess is the question.
well, he said suspicious shit. Again, we're paranoid people. I don't know who I'm meeting or where I'm going to run into while I'm there.
Did I hear you correctly that you're paranoid people?
Yeah, I'd be paranoid. You're going to meet a bunch of different people that you've never met.
You're going to meet with a bunch of terrorists, aren't you?
Objection, Judge. Argumentative. I would join. He hit the buzzer first.
Well, it's not argumentative, I mean, you can answer the question, however you so choose. So I'll overrule it. Question for me.
Thanks. I mean, you're going to meet with a bunch of terrorists, aren't you?
I wouldn't call these people terrorists, no.
Okay. Can I have 61, please?
see the attorney.
Can you pause that for a second?
Mr. Ralston, can you go back to you?
Thank you, Judge. Can I have 61, please? And if you could listen to this and look at the transcript.
I do all at the same time you take copies, you hire a copy. There you have that, and you like it, that, right?
Are they gonna?
Now, we're not gonna take it more morning, now we actually have something to validate that we have their counterparts. I like having copies, no, every day, that's a great enough, we need on that, and all fuck shit. And that is part of it, and our own.
This is part of the Dublin meeting where you're networking, right?
Yes, sir.
Okay. Now, I want to reorient you for a minute. I'm going to come back to this. Yesterday, on direct exam with Mr. Nunzio, you talked about how on Sunday morning at Luther, September 13th, or actually Sunday afternoon, was your testimony, I think, that you and your brother were in a meeting with Adam Fox, and Adam Fox was talking about some things that really concerned you. Do you remember your testimony on this point?
Yeah, I remember stating that it wasn't just Adam Fox that's the reason that I got concerned, yes.
And you locked eyes with your brother, and it was a very important moment in time, right?
Yes, sir.
Okay. Adam Fox at Dublin, as early as June 6th, is talking about taking hostages, right?
Yeah, he's rambling on, but there's a whole bunch of people rambling on, but yeah, you can see he's talking about it, sir.
I mean, his statements are clear to hear. Would you agree?
I didn't hear him clearly. I can read him clearly, but
Are you saying that this is another thing that you didn't hear in Dublin?
there was a lot going on there, yeah. There's a lot of rambling going on in the background. And again, he's ranting about stuff that, is he
Okay.
serious?
Okay. What I'm trying to get you to tell the jury is yes or no, or I don't know. Did you hear these statements by Adam Fox where he's talking about that human life is the value to it, right? Did you hear that?
I'm gonna, like I say, I don't know what all I heard of him talking. There was a lot of people talking in that audio.
Mm-hmm. So again, this is something that you claim you may or may not have heard.
Yeah, I
Okay.
guess I'm gonna stay with that.
Okay. You said you're going to stay with that?
Yes, sir.
Okay, I just want to make sure I heard your testimony. Thank you. Who's Charles Lewis?
Charles Lewis?
Yeah,
I
I'm sorry, Lewis Charles. Or actually, it could be either Lewis Charles or Charles Lewis.
I think he's an old man that he was in a common law group. I'm not exactly sure who Charles Lewis is right off the top of my head, sir.
Okay, I'm going to show you proposed exhibit number 291, and to identify it, it's a text message dated.
We're gonna object, there has to be a question prior to.
Well, hang on. Let's do this. It's about time for our morning break anyway. Let's do the jury and we'll do this. All rise to the jury. Can I see it?
Sure.
Okay, the record can reflect, everyone can be seated, thank you. The record can reflect the jury's out. Proposed 291, Mr. Ralston first talked to me about business sought incivility.
Yeah, it's being used to ask, or rather, for two reasons, under 613 to impeach. That is, to ask the witness about his ideology towards the government, and also that under 801D2, I think it's going to be admissible to show what his ideology actually is.
Mr. Nunker?
Your Honor, this is a random conversation that takes place on June 4th, 2020. This is before the June 6th Dublin meeting. This is a random, I assume, a chat conversation about Muslims and drones. It has nothing to do with this case. Okay, we have heard ad nauseum the prosecution's theory of my client's ideology. How does this add to material support? We are in week 4, Judge, and if he's going to ask the witness a question, having done hundreds of trials, he has to ask the witness first whether or not he made these statements and who he's making these statements to. And if the witness says he doesn't remember or he affirms what's in that email, that chat, then he can then he can give it to the witness to refresh his memory. What he's doing is he's asking these brief questions, having the witness take a look at it, and then catching the witness off guard, having looked at something that he hasn't seen before and hasn't prepped prior to coming to trial. And so this is just improper. This is improper impeachment. The premise of refreshing the witness's memory is based on a question asked, whether or not he said it or didn't say it. To ambush this witness, to make him look like, I don't know what this is, or you get these far-out questions, it's just improper.
Right.
I'd say it's irrelevant, and I'd say that there has to be a question. The only thing he asked him is whether or not he knew this Charles Lewis was in this. This is improper. This is an ambush tactic that's been used time after time.
Mr. Ralston, is it being sought to refute a particular comment or particular testimony?
Yeah, a couple of things. I mean, one, he's kind of adopted a certain ideological point of view that he's a Trump supporter, and that's fine. It refutes that. It also talks about his ideology in terms of his hatred towards the government, so that overcomes the relevancy challenge.
Okay.
This has been discussed before, Your Honor. It's very cumulative.
Well, I guess at this point, there's nothing point by point that the court sees that would be necessary to introduce this exhibit at this time. I think that the one line that deals with that is this event has nothing to do with Trump or working security for marching in Sharia law. I guess that to some extent refutes some of the testimony you provided yesterday, but I think that was already refuted at this point. Plus the other, what I would phrase as the smaller portion of the text of this document. And so it would be cumulative in that sense, plus the other text attributed to either Mr. Lewis or to Mr. Null, I think there are some 403 concerns. So at this point, the court will not allow commission to propose exhibit 291.
Understood.
If it needs to be used to refresh our collection or something, then it would be admitted, I mean, fine, but the content of that would not be admitted.
Understood. Thank you, Judge.
Anything else for anybody before we take a break?
So thank you.
No, sir.
Mr. Stiver, Mr. Barnett?
Oh, Your Honor.
Okay, and I'm sorry, I should have given you an opportunity to weigh in.
I got a real problem with him referring to our clients as terrorists.
Well, so here's the question itself is not argumentative. I mean, I understand the word and the power that word carries, but the answer can undo, so to speak, the question. I mean, the one that I thought was actually objectionable for being argumentative was where Mr. Wilson said something effective, and you claimed that, like you claimed the other thing, and what the court would have said is that his testimony is what it is, and the jury will make that determination. I understand wanting to draw distinctions. And so, again, I'll just do this with both hands. But whether or not we like a particular word and whether or not it makes it a fair question is a different matter.
I guess it's not whether I like it or not. The way they sit here today, they are presumed innocent until that jury is given the charge and sent back into that room, and then they come out and they say yes or no. But right now, they are innocent. They are not terrorists. They can't be labeled terrorists. They're not guilty right now. So I've asked that the council refrain from calling them terrorists or insinuating that they're terrorists.
He didn't ask about any of these three individuals. The question was in reference to the people who were at the Dublin meeting, which, in my understanding of who was in that room, did not include, when referencing other people, does not include Mr. Mahler, does not include Michael Null. And since it was referred to as other people, it would not have included Bill Null.
And we've heard no testimony that other people were convicted other than Adam Fox and Barry Croft, Judge.
I understand you were both in the room, and so that's that.
Your Honor, it does draw a legal conclusion, subject to the listener giving an opinion about his thoughts about other people. That will, in my opinion, potentially open up unnecessary doors. And that's why we're objecting to the use of the word terrorist, because it's an opinion-based statement. We're these terrorists. Now, if he wishes, if Mr. Wilson wishes to choose to go down that path, then he will be subject to the answers given by my client regarding people being terrorists and not terrorists by virtue of whatever reason the witness decides. It's a legal conclusion, and there's been no evidence or proof that any of these people are and/or, and it's not relevant, or admissible, whether or not anyone had been convicted of terrorism or not terrorism. This is a legal conclusion that it's being conveyed to the jury subversively to get them to believe that these are all terrorists because the Attorney General's office is saying it. It's a legal conclusion, Judge. But I just put the Attorney General's on notice in the court that if he's asking for opinions of witnesses, of a witness regarding the label of someone, then you're stuck with an answer.
Okay. This is what I'm gonna say, and then I think I've given everybody their piece to talk on this subject, so we're gonna call it good. His question was not improper in the court's mind. He said, were you in the room with terrorists? Something along those lines. That may not be the exact word. The question was answered by Mr. Null. That question in and of itself does not require a legal conclusion. That question is not improper in the court's mind. Would any particular follow-up questions be inappropriate? Quite possibly. It wouldn't be dissimilar from an attorney cleverly asking questions about federal agents being in a particular place or phrasing it in a certain way so that it perhaps draws the implication of entrapment, for example, without mentioning the concept or the word. So just because somebody is very good at asking a question doesn't necessarily make it objectionable. However, certainly if there are any follow-up questions, they may be. That's how I'm going to leave that. Okay?
Can I is the court prohibiting counsel from identifying federal agents or FBI informants during any course of this?
Not at all.
Okay.
Not one bit
Just want to make
whatsoever.
sure that's clear.
Nope.
Okay, thank you, Judge.
Okay. Anything else for anybody?
Well, thank you.
Okay. We'll be on recess, let's take 10 minutes. 25 minutes.
Judge, I don't like have any confirmed illnesses, but out of an abundance of caution, that's why I'm wearing this mask.
Okay.
I don't know if you want to tell the jury, that I have a cold.
Generally, I would not,
Okay,
unless
I
there was a
just-
reason to alert somebody for medical.
Yeah, I just don't want anyone to think that I'm dead this
That's fine. I mean, there have been several people talking, I think it's kind of going around the room at this point, so, I mean, unless there's, if you want me to, that's fine, but otherwise I generally would not.
No,
Okay.
certainly, for council wear masks too, but.
Different thing.
Yeah.
I didn't say that.
Muscle.
I'm just teasing.
People versus muscle. Bill? Willie? Probably the laser pointer. That would be-
Oh, yeah, thank you.
Okay, if you did.
There's a couple of questions, basically it's about, what's that? Oh, yeah, that's fine, we can go back on record. The jury sent out a couple of notes. One deals with a juror who needed a note from the clerk, we dealt with that previously. Because the trial has continued, she just needs an updated one, so I'll give that to the clerk. Because she's identified and continues identifying information, that one I will not include in the court file. And then there was a question, do we get the exhibits when we go into deliberation? Will we get a chance to listen to the audio if it's admitted? And then there was another one asking to replay AA, BB, and CC. I'm sorry, can we hear those exhibits on the black speakers? They were hard to hear. What I'll just generally explain to the jury is that they will get all of the exhibits. We're going to give it to them on a computer so that they can play that at their leisure. My preference would be to not replay those now. I mean, they're admitted as exhibits and they can simply do that.
No objection.
Any issues with anybody for
No
that?
objection.
No, sir.
Then with that, all rise for the jury.
I was able to get my stuff on a front drive.
Oh, perfect. Thank you.
A backup one as well.
Appreciate it.
These read in this direction, right? Thank you. No, I'm not gonna get it. Yeah, maybe I will.
Okay, everyone, please seated. Welcome back, ladies and gentlemen. Got your notes for the juror. Given the fact that the file continued their update, that information will be given to the clerk's office and they'll take care of that like they did last time. As for the other notes that we received about the exhibits, there's one generally asking about whether you get the exhibits when you go into deliberation, and then one about the AA, BB, and CC being played on the black speakers. We're not going to replay the exhibits for you. They've been admitted, and so just to sort of fast forward to give you an idea, you will get all, whoever the 12 are that will go in and deliberate, they will have all of the exhibits when they go into the jury room. There's actually the phrasing we use is a clean computer, meaning that there's nothing else on it. Can't connect to the internet, for example, so that research can't be done, that kind of thing. It will have a digital or electronic copy of all of the exhibits, so whether it was photographs, whether it was audio, video, so you would be able to replay any of those that you wanted to. It would be all of the exhibits that were admitted, so the people's exhibits, and then Mr. Mahler's and Mr. William Null's exhibits, those will all be provided to you so that you can play them as part of the deliberations. If you have any further questions, let us know. I think that answers those generally. And if you'll recall, we're still in the cross-examination of Mr. Null by the people. Mr. Ralston, go ahead.
Thank you, Judge. Hey, Mr. Null, I want to talk about the Boogaloo a little bit with you, okay? What's your understanding of what the Boogaloo is?
The Boogaloo, I guess what the interpretation of it is the, I guess, a revolution happens in this country. As far as the theme goes and everything else, people called it like the Big Igloo. Most of that is, they were making light of something. I don't know how to exactly explain it, but the Boogaloo movement was like, yes, there's a revolution or something's gonna happen.
A civil war, would that be another way to say it?
I guess you could say that, yes.
Okay. Did you believe in the Boogaloo?
Do I believe in the Boogaloo? Was it gonna happen? I didn't know.
Did you want it to happen?
I didn't want it to happen, no. We always prepare for if the world came to an end, that's what I was trying to be ready for.
Okay. We saw some pictures during our case in chief that we presented, Boogaloo patches that you were wearing at the Capitol. Do you remember that?
Yes, sir.
Okay. Why were you wearing a Boogaloo patch at the Capitol?
It was given to me by a friend of mine.
Okay, I understand that that's how you received it, but what I'd like you to tell the jury is why did you wear that symbol very openly on your, on your ballistic armor where everybody could see it? What was the reason for you wearing that?
Well, the beginning of the Boogaloo movement, the Hawaiian shirts, all that stuff, that was actually one militia here in Michigan, from my knowledge, that started wearing Hawaiian shirts. And they literally would not wear any body armor, wouldn't do anything. They might have a rifle or pistol on them. One guy had a onesie that was Hawaiian. That's how the Boogaloo and the Hawaiian shirt started there. Whether somebody else latched onto it in the beginning and started doing, pushing another ideology on it from the beginning, I don't know exactly how that went.
I'm going to try to redirect you to my question. I mean, let me try it this way. Do you remember Scott McManus when he testified?
Which one was Scott McManus?
He was the head of the governor's protection detail.
Okay, yes, okay, yeah, I know what you're talking
Okay.
about now, yes, sir.
I mean, he wore the uniform of the Michigan State Police, didn't he?
Yes, sir.
Okay, and he had a badge on and that told people the organization that he is from.
Yes, sir.
Okay, so I'm going to ask the question again. When you're at the Capitol, why do you have a Boogaloo patch on for everybody to see?
I got all sorts of patches on, sir. That was just one of my patches. I didn't think anything of it.
Okay, I'll move on. Did you ever tell anybody that you wanted the Boogaloo to happen?
I guess it would have to be in the context. I don't know if I ever did or not.
Okay.
Yeah, we approach.
Sure. Thank you, Judge. May I continue?
Yes.
Thank you. The question was, did you want the boog to happen? Do you remember my question?
Objection foundation, we'd ask what advantage, or is this a permanent thing that the prosecutor's asking, we're objecting to foundation? Is this to a particular event, or is this forever? Or what's the purpose of the punishment for purposes of foundation?
Well, Mr. Ralston, in terms of the timeline.
Sure.
General question or in response to something specific?
Let me focus at a more specific date. In June of 2020, did you want the Boogaloo to happen?
I don't recall if I had made a statement or not, sir.
Okay, I'm going to show you what's been marked for identification as exhibit number 292. You look at this and you direct your attention. You can read the whole thing, but I'll direct your attention mainly to the green box. And let me know when you're done reading that.
Okay.
Did you tell Tommy Wilson, that help refresh your memory as to whether or not you told Tommy Wilson on the 21st of June of 2020 that we will have the boog for sure?
My name's on there, but yeah, I don't recall that conversation. I mean, I see that's my group, but I don't know what it's referring to or what's going on in the world there.
Okay, well, I mean, when you say we will have the boog for sure, that's a text message that you sent, correct? To Tommy Wilson.
It was a conversation between me and Tommy Wilson, yes.
Okay. And that's what you said to Tommy Wilson, correct?
Yes,
That's
but
an answer, Judge?
I don't know the context.
I don't think he has.
Okay, well, let's do this. Mr. Null, that portion of the text message you reviewed, that was a text message you sent, correct?
Yes, I was replying to somebody else's comment, yes.
Yeah, I understand. Okay, so now we know that he sent a text message. So anything beyond that, I guess the objection doesn't need to be dealt with based on the court's questioning. So Mr. Ralston, let's go ahead, and then if there's anything objectionable in the future, Mr. Null can make one.
Thank you. I think you told us yesterday that you didn't really know Adam Fox very well. Is that correct?
Yeah, I don't know him very well, no.
Okay. When was the first time you remember meeting him?
The very first time I remember meeting him would have been Lansing at I was working security at a building downtown.
Okay. You mean you had a job working security?
No, I was invited by the business owner. Bill Robinson was invited by a business owner.
Sure.
To come and stand at his business. There was a protest going on there, and he asked me to ride with him, and I rode with him.
Actually, it brings up an interesting thought. You say you were working security like at the Capitol. I mean, nobody paid you to do that, right?
No, I was asked by whoever was putting the event on, and we agreed.
Okay, nobody was paying you is my point. And all these things that you went to, that you say you were working security, nobody's paying you, is that correct?
No, I'm volunteering my time.
And that's time away from work when you're not, getting paid, right?
Yes, sir.
Okay, and did anybody in the history of man ever ask you from law enforcement, we need your help, Mr. Null, come in with your militia and help us protect the city?
No, I wasn't asked by the law enforcement.
You had text exchanges with Adam Fox, is that correct?
Yeah. Sure.
Okay, going to show you proposed exhibit number 293 here, and ask you to review from the bottom up.
Yeah, we, one second, Mark.
Ladies and gentlemen, I have to excuse you for a couple of minutes. All rise for the jury. So, take a look at all of them.
Sure.
Okay, everyone can be seated. The record can reflect that the jury's out of the courtroom. There's just some financial issues that we're going to have to deal with. Excuse me, have the jury excused rather than.
Thank you.
Is this what the text message does, Mr. Wilson?
I'm sorry?
I was a little confused because
Sure.
you have them switching bubbles here. Okay. But, so who is this? only for you.
Yeah, so
I can't help you on this one.
this is Adam Fox.
But then why does it say Bill Null here?
This is how the report reads, and it comes from his phone. So it's a, I don't know why the report is up.
I've never seen a report like this.
Now, our little now.
Okay. I would argue that this is confusing because it's hard to follow who is.
Well, why don't we get through those and then we can.
So we just-
Okay.
We're objecting to the admission.
Okay.
The format is a format the council's never seen before. We're gonna argue foundation. This was created by Agent Impola. I'm not sure where they took this from, but clearly it does not denote any meeting my client had with Adam Fox on or before the 30th or prior to the next time they met up. This is trying to slide a meeting that never existed under the door, Judge, and we're objecting to this format. You can't follow this.
Can I see those?
May I ask for a second?
Yep.
Oh, well.
Better if you stay away.
Oh, I got a mask on.
And what I just handed the court is 293, 294, 295, and 296, I believe.
I'm gonna go through this one so you can have a seat.
Oh, thank you.
I'll give you an opportunity.
Yes.
Governor, just so the record is clear, I think the form of those exhibits is very confusing because it doesn't actually attribute who is saying what. We've seen several text message bubbles in this case in exhibits where it clearly identifies to whomever. So that there's some sort of context for the jury to look at. But this just says Bill Null on most of these bubbles on both sides with different colors. As the special agent pointed out, they're in reverse order, so they started at the bottom and go up, which is contrary to what we've seen with all the other exhibits. I just think that this would be very confusing to the jury.
Okay. Mr. Ralston, where did these come from?
The extraction from Bill Null's phone.
Okay. And meaning, am I looking at a document that was created based on the extraction, or I'm looking at the page from the extraction?
Both. I mean, it's a, the content is drawn from the Cellbrite report. And then, and it's, the reason it's formatted the way it is, because that is organic to, or original to the Cellbrite report.
Because it's an Android. The other ones, I think, the way the court would describe them is they're in the shape of iPhone bubbles.
Yep.
I guess is the way, for lack of a better phrasing.
It does matter.
I do know that this is Android. I don't know. Is that the reason for the difference?
The,
I'm just asking.
yeah, and, you know, I see council's point there in terms of, that issue. I think what I'd like to do is, reference them to the witness based on the exhibit number, ask him if, that helps to, you know, refresh his memory as to particular text message conversations he has, or has had rather, with Adam Fox about the meeting. And then I may seek to put them in and rebuttal through Agent Impola, who could then lay the foundation in a more concise way and explain it to the jury, you know.
Okay. Well, the question was, did you have text messages conversations with Mr. Fox. There was no text message conversation, question asked about the meeting or about any meeting that I recall. Maybe those were upcoming, but those weren't asked yet. And so I guess the way that I'll paraphrase, because I think Mr. Nunzio put a number of projections on the record, and I agree the formatting is different. I think based on the nature of the questions, I don't think it's confusing to the point where it can't be understood. I mean, I agree it's not as simple as looking at an online conversation, but I think that in 293, Adam Fox says his name, so to speak, on green bubble side. At least let me give initial thoughts based on the knowledge that I have so far, based on the testimony, and then we'll go from there for everybody, especially if you're not going to be sought for admission here. The question that he answered so far was, did you text Adam Fox? Yes, there's nothing relative to a meeting. And so 293 wouldn't be an impeachment because he said that he did have text message conversations with him. So that's the initial thought I have on that. The 294,
Judge, before you begin on 294, I think there's another question that needs to be asked, and that is, well, did you have text message conversations about the June meeting?
Mr. Wilson, would you speak up, please? Mr. Wilson, please speak up. We can't hear you.
Sure.
So the follow-up question is what Mr. Wilson was describing that would be asked of Mr. Null. Go ahead with the question.
Yeah, it would be, well, did you have text message exchanges with Mr. Fox about that meeting?
Well, the problem is, so the content of proposed exhibit 293, which I'll refer to them that way for record purposes, if the jury has a point taken on that. So the three on June 30th, there's a message, what's up, bro? Next message is Adam Fox, the name. And then we need to talk, and then the response is when and where. So I guess it could be argued that that's what that means, but it could very easily be argued the other way too. I mean, it doesn't say, when and where, well, we're going to be on the night of June 30th, et cetera, et cetera. So
I understand.
That may be a little bit much of a stretch, so.
He's trying to establish that the meeting took place on June 30th or sometime before Cambria. If you look at those exhibits, Your Honor, they've got different dates on them. Okay, so that's misleading in and of itself.
I understand, and I just said that 230 doesn't have to do with setting up a meeting, or 293, so
When and where does not mean that they had a meeting.
I understand. I'm not disagreeing with you when I'm saying that I doubt that 293 would be admitted for that purpose.
But you're now, I think the court was looking maybe to let the prosecution admit it so that each side can argue.
No,
Purpose of it.
I'm not doing that. I'm telling him that it doesn't indicate that a meeting happened. So far the question is, did you ever text, if the question is, did you ever text him on June 30th? And the question would be no. Okay, well then this becomes impeachment. If the answer is yes, then it doesn't. If the question is, can this be admitted to show that a meeting occurred on June 30th? The answer is no, it doesn't talk about it.
Bill counsel has some further inquiries if the court
I just want to make the record perfectly clear that a standard celebrate insurrection comes out in a essentially Excel form document where it says boo, boo, boo. They don't come out in text message bubbles like this. And I just want that, the record to be perfectly clear that it was purposely created that way.
Well, and the court is familiar with Cellbrite, whether it's whatever PDF, whatever the ending is of the Cellbrite report itself. I've seen it both on a computer screen and in the document format itself electronically. It can be exported as a PDF. The court is also familiar with investigators, for example, the detective with the Grand Traverse County Sheriff's Office can input the Cellbrite report into his system and output the messages into a text message format. So I don't disagree that when you plug a cell phone in and produce a Cellbrite report, it's not in this format, but I don't think the format in and of itself is an error, so to speak. It's just the formatting may be different from the text message. So, so that's 293.
So 293 is no.
Well, 293 was now, but 293 would probably be a no based on information for which it would probably be admitted. It's the only way that I can fix that.
Copy.
To propose 294, again.
Haven't gotten there yet.
Nope, but based on the content of the message, theoretically, based on some of the testimony yesterday, potentially for impeachment purposes, from what I'm seeing, and again, I don't know what's being offered for at this point. Any specific objection relative to that?
Could the court, I'm sorry, could the court read those aloud right now so that we have?
Sure.
Because we don't have a copy ourselves.
No, that's fine. And again, go bottom to up. The way from the previous message that I understand it is the blue, it's Bill Null. Text message is this one, one page, July 11th at 11:35 a.m. You going to this event today? I got 3 plus me. We'll be there around 12:30-ish. Response is 11:36. We are on our way to the camp. We have a bunch. Is, comma, our XO and 5 or 6 watchmen. Response, fuck yeah, man, good to hear it. And that was at 11:42.
You would object, how does that reference that the meeting took place on 6:30?
We're on to the topic.
No, that's okay. I don't think it had reference to do with that.
Well, the original set of questions, do you know Adam Fox, and how well do you know?
No, and I understand. I asked them to give me all of the messages so that we could discuss them while the jury's out. So that 294 or 293 is the one that dealt with that particular topic. These others I asked to see so that we could discuss them outside the presence of the jury rather than taking a break each time.
If the questions were, do you have any contact with Adam Fox before the Cambria FTX, I get it.
Well, and the difficult part is that I don't know why, well, let me ask for 294, what would it be used for?
Yesterday, he said he didn't know the watchman.
How does that prove he's a watchman?
He said, his statement was that he didn't know about any Wolverine watchmen. And the response from Adam Fox in his text message at 11:36 is, the part of it is we have a bunch, is our XO and 5 or 6 watchmen.
Okay, so that's a statement by Fox. It's not a statement my client knew anything Wolverine watchmen. And he said he met them, he's met them, and he found out who they were. But in terms of knowing them,
That's not what the case about here, but let's talk about 722. This one indicates, so 722, 942.
This is exhibit 295, Judge.
This would be Bill Null. Yeah, man, just working and training. Couldn't make the last meeting, had to help my family out. You good? Response. Date and time not listed for the response. Yes, sir, just try and put the pieces together, get a plan of action going. And then the next is response from Bill Null, same date at 9:50 a.m. Yeah, I hear that. Just keep setting brush fires and hoping the blaze will start. 722, 1034 response from Adam Fox. It's yeah, buddy. And what?
This goes to the July 18th meeting in Peoples, Ohio, that Mr. Null didn't attend, but it shows knowledge that he was aware of it.
Your Honor, the witness said he was invited yesterday to the meeting, but never went.
So I could disagree with that. I don't think the 295 is correctly here. There's a sufficient nexus to establish that. Anything else anybody wants to put on the record for 295?
No, thank you.
And then proposed 296, 8/10/2020 text messages, Bill Null and Adam Fox. First one, no date and time, would be from Adam Fox. Can you come by my vacuum store one day? Question mark. We can speak securely in the basement. Response 8/10/2020, 5:20 p.m. from Bill Null. Yeah, Wednesday evening work? Question mark. And then same date and time stamp. What's the address? Question mark. Response from Adam Fox, 5:21 for sure. And then I guess the best way I can describe it is 19 milliseconds later. It's the same date and time stamp, about 4 milliseconds. He gives an address in Wyoming, Michigan, that I would presume is the vacuum store address. But I don't say that for purposes of the record. I don't know if you need. And then the response from Bill Null at 6:43 p.m. Cool, brother, I'll be there. I'll let you know when I'm on my way. For purpose being.
That he met with Adam Fox at the back shack. It's evidence that he had a meeting with him
We would object, there's no indication there was a meeting. There might have been talk about setting up a meeting, but to establish for this jury that the meeting existed, I think would be improper. It doesn't mean that it's being established. It implies to judge, and we don't want implications going to the jury as fact.
Mr. Ralston, any response?
Just what I said earlier, Judge, circumstantial evidence of a meeting.
And additionally, there's no indication he's on his way. There's no follow-up thread saying we had a great meeting. There is nothing indicating that a meeting took place. There's nothing. It's just, hey, I'll meet with you. That doesn't mean a meeting took place. If there's any other evidence the prosecution has suggesting it was a great meeting, you know, it's good to see the guys, on my way, just left the back check, there's nothing. This implication is improper.
Okay, Mr. Sackey, Mr. Barnett, anything for you all on this one?
Judge, I'd simply join Mr. Nunzio's comments.
Thank you for asking, I think that will be an easy.
Okay.
Stay neutral.
So, proposed 293 and 295, I've already determined that those are out. 294, depending on the question marks, I do believe based on the witness's testimony from yesterday, I do think that is appropriate for impeachment purposes. I think he indicated at several points that he didn't know any of the watchmen and wasn't familiar with the organization. I mean, I guess the jury can get it no way if it so chooses, but for impeachment purposes, it does go that. So,
Just as a reminder, the court had prohibited counsel yesterday with respect to the June 30 meeting that we had not filed a alibi notice with respect to where he was.
Sure.
So now, if he gets to, does he get to ask the witness where he was if he wasn't at the meeting? Does that violate alibi? Or does he have to prove alibi at this point?
Sorry, 294 deals with text messages from July 11th.
Okay,
And this is the one that mentions the watchmen.
okay.
And so the court, the ruling from the court is that for impeachment purposes only, would go to the statements made yesterday if so sought by the people. That would be appropriate for those purposes and those purposes only. And then 296.
This is dealing with a different date.
Yeah, this is not for June 30th. It's entitled August 10th at the top. Let me think about this one for a second. Well, the testimony was yesterday that he didn't have any one-on-one meetings with Adam Fox. So for impeachment purposes, the issue for the court is that it's a weight argument as to whether or not the jury could give it any weight as to whether or not a meeting happened. Obviously, the implication is that it did, and the argument can be made on the other side. But in terms of 104 and admissibility, the weight isn't the issue for the court. The question is, does this, if this is offered to refute testimony that he never met one-on-one for impeachment purposes, it certainly at a minimum implies that. Whatever way the jury would give it, I suppose it's certainly up to them as the trier of fact. So, I mean, obviously, for 294 and 296, the proper line of questioning would have to trigger the admissibility. But any further objections, you want to place on the record, Mr. Null? Okay. So, Mr. Ralston, let me give these back to you. And presumably, the court will determine two proposed 293 and proposed 295 are not admissible for any reason. Obviously, the line of questioning would dictate relative to proposed 294 and proposed 296 for impeachment purposes. Would they be sought as substantive evidence?
Not at this moment.
Okay. That's a different bridge we got to cross.
Yep. Thank you, Chief.
Anything else for anybody before we bring it back?
No, thank you.
No, sir.
All right.
sir.
You got enough water?
Yeah, I think so, sir.
I just said them.
Yeah.
Okay.
Yeah, it's a habit. I smoke, so I gotta.
Okay, we're gonna.
Thank you. Hey, Mr. Null, let's talk a little bit about how well you knew the Wolverine Watchmen or anybody involved in them. You know, you said that networking was very important to you. Is that correct?
Yep.
Okay. I mean, and were the Wolverine Watchmen present in Cambria?
Yes, there was some there.
Okay. And what Wolverine Watchmen were there?
There was, I know Dan was there. I know, Brandon Caserta was there. There was a couple more there too.
Do you know a man named Ty Garvin?
Yes, Ty Garvin, he was there too.
Okay. Do you know a man named Dan Harris?
Daniel Harris was there too.
Okay. And they all trained at Cambria, is that correct?
Yes, they were there.
Did they train?
Yes.
Okay. And you went there with Mike, right?
Yes, we did.
And when I say Mike, I'm talking about Michael Null, your brother.
Yes, sir.
Okay. And you said that I think the two of you were in Menominee camping.
Yes, I
Is
was
that
in-
correct?
Well, we were staying in the UP. We were on vacation with our family.
Okay. You and Mike, I mean, you're twins that were born on the same day, correct?
Yes, sir.
Okay. How would you describe your relationship with him? Is it a close one or a distant one?
No, we're close twins, yeah.
How far away do you live from each other?
I don't know, 15 miles. I don't know the exact number to it.
How long does it take you to drive to his house?
15 minutes.
Okay. You two work together?
Yes, we run our own business together.
Okay. Yeah, you work together every day?
Not every day, no.
Okay. I mean, in the course of a month, I mean, how many days a week do you guys work together in your building business?
Depends on the job and it depends on what's going on.
Okay. I mean,
If you want an example for a certain, I mean, it depends on the month.
sure. I mean, you and Mike are real close. Is that a fair summary?
Objection asked and answered, Judge.
I don't think I asked that question.
You did.
Well, hang on. I don't think you asked that question directly, but I think you answered a question similarly to it, but it's not necessary.
Okay.
At least think of it.
Who runs the business?
I'm a licensed builder. I'm the one that has the business. But Mike does, he runs it with me. I'm the licensed builder.
Okay. I mean, you're partners?
Yeah, we pretty much do that together, yes.
Are your families close?
My entire family's close, not just my brother and I, but yes, my entire family's close.
Okay, I want to focus just on Mike, and Mike has some children, right?
Yes, sir.
And how many kids does he have?
Well, he's got a stepson and he's got a daughter.
Okay. And your children, how many children do you have?
I have two.
Okay. And the cousins, are they close?
Yes, my entire family's close.
Okay. Your wife and Mike's wife, they have their own relationship. Are they close?
I would say so.
Okay. And do you get together as a family? The two Michael Null family?
Yeah, Council's left this going on long enough. We for relevance.
Well, certainly the general topic is relevant, and of course mine, I think we've established that no families are close.
I'll move on, Judge. I'll move on. Okay. So you guys are up in Menominee camping together, you and Mike, right?
Yes,
With your wives,
yes,
with the children.
yes,
Family vacation, right?
yes,
Okay. And you and Mike get in the car and drive to Cambria during this vacation, right?
yes, sir.
How far is it from Menominee to Cambria? How long does it take you to make that trip?
Oh, I don't recall the exact time on it, sir. That was 3 years ago.
Would be
I
about
don't-
2.5 hours maybe?
It very well could have been, yes.
Okay, and this is a July vacation up north camping with both your families, right?
Yes, sir.
And you and Mike take time out of that to drive down to Cambria, right?
Yes, with one of my sons.
I was just gonna bring that up now, and you bring your sons to these networking opportunities, don't you?
This was an FTX.
Okay, I think you said you went to it to network, right?
Yes, but it was an FTX. We enjoy doing FTXs, yes.
Okay, and who's at the FTX? But it's Barry Croft is there, right?
He was there,
The
yes.
same guy that was down in Dublin, right? You heard what he had to say down there.
Yes, sir.
And then Adam Fox is there, right?
Yes, sir.
And same guy that's in Dublin, and we heard what he said, right?
Yep.
Okay, so you get to Cambria, and and you take basically a day out of your July vacation in the UP to get down there and do this training, right?
Yeah, we were there for a few hours, yeah.
Okay. Can I have exhibit 211, please, Adam? Hey, Mr. Null, take a look here. You were on Signal, weren't you?
Yes, sir.
Okay, and tell ladies and gentlemen what Signal is.
It's an app on your phone that, I don't remember who set it up, but it was an app on your phone that is separate from your cell phone. So it's on your cell phone, but it's its own chat.
Okay, and the first,
I'm going to object to this time. They put up exhibits, they don't give the witness enough time to respond to a question. And so it catches the witness somewhat off guard because everybody's scrambling. Everybody in the room scrambling to figure out what's up there. We requested a question be asked, that the witness be given the opportunity to read the entire exhibit and then respond to the prosecution's questions. He's trying to get the witness off guard between questions and looking up there. Okay, so that's what we're requesting, respectfully.
Well, that's not what happened. Mr. Wilson, that's not what happened before. When you referenced the audio exhibits, for example, he put the entire transcript file on screen. He played the entirety of the exhibit to orient the witness and presumably anybody else. And then he went back and asked specific questions. And if it was in reference to a particular phrasing, Mr. Wilson would use the laser pointer to direct the witness's attention to it. We haven't gotten to any particular questions about this exhibit, which is 211. But if you were going to be asked a question about one of the conversations that appears in one of these bubbles, obviously he would need to be given an opportunity to review the entirety of the message before he was asked for that, which is in continuance of what has been done previously.
My concern is everybody's attention is directed on the exhibit, okay? And my client is looking around, trying to respond to the prosecution. So you're gonna get lost in the sauce unless there's a question, but everybody's looking at the exhibit and trying to get the substance of the exhibit down. And the fear, my concern is that, maybe there's not enough concentration given on the answer with the question. And they've been doing that, and we're respectfully objecting.
Okay, so I'll overrule the objection for what I've stated. Obviously, the witness will take time to review it. And Mr. Null, if you need additional time and after a question is asked, you would prefer to turn around and review and then spin back around, that's entirely your discretion, sir. Whatever is easier, it's the same option I would give anyways. So,
Yes, sir.
Why don't we do this though? Are you going to ask questions relative to this?
I was,
All three bubbles?
yes.
Okay, Mr. Null, why don't we do this? Let's start out with having you take an opportunity to review the text for each one of those. And if you could just spin back around so once you're done, that way we'll know if you completed that.
Yes, sir.
I'm gonna need you to take a look at these while ask you some questions. Okay, so on the first bubble here, on this message from you, now you were telling us what signal was, I think, when Mr. Nunzio objected. Why don't you finish your answer and tell the ladies and gentlemen what signal is?
I thought I answered that question, sir. It's an app on your phone that you download that it's not a text message, or it's a messaging app.
Is it encrypted?
I don't, it could be encrypted chat.
Do you use it to help you to avoid your conversations being known to others?
It could be, I suppose. I don't remember who set this chat up.
Well, in terms of the signal, you have to download that on your own device.
Yes, you do.
So did you download Signal?
Yes, I did.
Can you tell the jury why?
We set up our groups on that outside of Facebook.
Is that part of what you were talking about in Dublin when you said, you know, we have to establish comms?
We have to get a different communication.
Okay. And this makes it more, I mean, the people that are on Signal, I'll move on. Let's talk about what you said here, okay? On the 15th of September 2020, this would be 2 days after the Luther FTX, correct?
Where's the data? Oh, right there.
Yeah.
Yes, sir.
Okay, and it'd be 3 days after you traveled to Antrim County, because you did that on the 12th, right?
Yes, sir.
Okay, and you said, we are at war now. We have been. I don't see how things will get any better without bloodshed. No matter who wins this election, they won't go by the Constitution. We will be forced to comply or the pigs will kill us. I have two questions here. Number one, when you said we are at war now, what did you mean?
I don't know the contents of this thread.
Those are your words, right?
It is.
Okay.
What's the contents behind it?
Who are the pigs that were going to kill you?
Well, it depends again on the contents. Could be law enforcement, could be the government. I don't know what's the rest of the contents to the
Okay.
question.
Let's move on to the next. This is from the face. You were on the. Go ahead.
I didn't know whether to turn back around.
No worries. No, and let's stay with you were part of the Michigan Liberty Militia Roundtable Facebook group, correct?
Yes, sir.
And Mike was part of that too, wasn't he?
Yes, sir.
Okay. And this message is from the 16th, a day later, and it said. You said it's already been enough, but when the rest of the free people stand with us, we will be unstoppable. What did you mean when you said we will be unstoppable?
If the American people stood together, again, I don't know the contents or I don't know what we're talking about there. That's a statement that I made, yes. If the American people stood up.
Stood up to what?
Stood up for themselves.
Stood up against government?
Or whoever is keeping them down, yeah.
Okay. And then last, at the bottom here, this another from the Facebook MLM roundtable. This one, again, on the 16th, correct? And then that's, I think, 4 days after you came to Antrim County. Is that correct?
Yes, sir.
Okay, and you said, this is the time to get prepped, brothers. Shit ain't ever going to be the same. What did you mean by that, Mr. Null?
Again, without the rest of the contents of the message, I have no idea what we're actually talking about there.
Were you talking about the Boogaloo?
Again, without the contents of the rest of the questions, I have no idea what we're commenting on there.
Fair
I'm
enough.
sure there's plenty more to that exhibit besides them messages.
Can I have exhibit 124, please? And page 4. You need more water, Mr. Null?
I think I'm good, sir.
Okay.
Thank you.
What number is this, Mr. Walton?
This is 124, and I'm, if I could have page 4, please. And can you go down the first box under September 5, please? You were part of the Facebook coalition chat, is that right, Mr. Null?
Yes, sir.
And tell the ladies and gentlemen on the jury who's on that chat.
I don't recall who's all on that chat, sir.
Um,
I'm not sure exactly what the coalition was.
Okay, can we go back to page 1, please?
Is this on, oh, it must be on Facebook. I didn't know what platform, sir. I didn't,
No,
like I
no
said,
worries.
I don't know what.
Just give us a minute to get to page 1 and I'll ask you. I'm sorry?
Do you have a paper copy?
You know, can you go get the book? Thank you. Hey, we're gonna get the book here, but until that comes out, you turn around there, looking at the participants on this chat. You mentioned you knew a man named Tom Garvin, correct?
I didn't even know his name until after I was arrested.
I mean, but you know Ty Garvin to be a Wolverine watchman, right?
I do now.
And you know, yeah, thanks. And you know, Joe Morrison, right?
I do not know William Null.
Did you know him to be a Wolverine watchman?
I do now.
Okay. And did you know his handle to be George Bunyan?
I have no idea who he was.
Okay. Okay.
What exhibit am I looking at, sir? I didn't want to just.
You know,
fumble
no
through
worries.
this.
You can go to, if you want, you can go to 124 there. We're going to leave that up for the jury, obviously. And if you take it out of the sleeve, I'd ask you to go to page 4. They're not numbered, so you'll have to count them.
Presumably you're going to have something about something on page 4.
Yes, sir.
Okay. Mr. Null, when you get to page 4, why don't you take time to read the entirety of that page, sir, and then just look back up when you're done so that you know. Okay.
Yes, sir. Page 4, sir.
Yes, sir. Okay, page 4, please. I know you probably didn't count them, but would you agree with me this is a 10-page exhibit?
I'll take your word for it, sir. I
Okay.
did not count him.
And what I want to direct your attention to on page 4 there, the second box.
Yes, sir.
Okay, and you said, if I'm correct, and you can read it from there, you don't have to spin around like this, Mr. Nunzio was talking about there, but you said during this coalition chat on Facebook, from where I'm standing, if you're not ready to fight, you're doomed. We are at war against half the sheep in this country and the rest of the world. If you back the blue, you're a fool. They're just as much the enemy of freedom as the feds and BLM/Antifa. Let me ask you a few questions about this.
Yes, sir.
You say here in this 10-page exhibit that we are at war. What did you mean by that, Mr. Null?
There's violence in the streets.
There's a lot of violence in Berry County, is that what you mean?
Doesn't have to be in Berry County. It's just
Okay.
in this country at this time, there was a lot of violence in this country.
Okay, and who were you at war with?
This
When you
country-
say we are at war, who are you at war with?
The country was at violence, and every day there was violence, and people that are not prepared, if they continued down that road, they were going to be doomed.
Okay, but I was asking for the who, not the why.
I don't know who yet, but they are burning down our cities.
Okay,
Is that what we're talking about in the rest of the chat? I don't recall.
okay. And then you say you say we're at war against half the sheep in this country. Who are the sheep?
The ones that just went and locked themselves in the room, or they attack you for having a different political belief.
Okay. And when you say, if you back the blue, you're a fool. When you say the blue, who are you referring to?
Police, but it has to, like I said, there's got to be contents behind it.
Okay, I mean, this is a 10-page document. I mean,
Sir,
feel free to look at anything in there to get your context right.
no, I'm assuming they're talking about rioters and that in there just on this page. So
Well, the police weren't rioting, were they?
no, they were standing down while the violence was happening.
I think yesterday when you testified on direct, you said you're a supporter of law enforcement, right?
Depends on law enforcement, yes.
Okay, but here you make this, I mean, you're not talking about who, I mean, you don't make any qualifications. You say, if you back the blue, you're a fool, right?
I said that, yes.
Okay, and you feel that they're just as much the enemy of freedom as the feds and BLM and Antifa. You're kind of lumping all of them together, right?
Yes.
Okay. The next box that follows here is you talk about that you're doing this because you're standing up for your kids, right?
Yes.
And you're teaching your kids what you do, right?
I'm teaching them I was teaching them to be proficient in a lot of things in life skills and to stand up for themselves. Yes. Are we done with this exhibit, sir?
Yes, sir. And if you actually, why don't you go ahead and put that back in, or if you would, yeah, thank you. Are you at 119 there?
119, sir?
Yes, please.
You want me to take the exhibit out or?
Yeah, if you would, please, and just look at page 4 there and read any part of it you want and let me know when you're done.
Page 4?
Yes, sir. It's the last page, and not numbered. And yes,
So the last page, so it's on 813.
yeah.
Am I just reading the box or am I reading the whole?
You can read anything in that 4-page exhibit, but I'm going to direct your attention, and my question will be centered on that box
On
the
that
end,
box,
at the
okay.
bottom of page 4.
Mr. Null, why don't you take the time to read the whole page, sir?
Yeah, read the whole page. Okay, yes, sir.
Mr. Wilson, which exhibit number is this?
119.
Thank you.
All set, Mr. Null?
I believe so.
Okay. And on then page 4 there, I think you said on August 13th of 2020, well, no, because a cop is above the law, a person with a felony is below the law. Cops are terrorists, plain and simple. Did you think cops were terrorists, plain and simple, back in August of 2020?
Yeah, it depends on the situation.
You didn't qualify it here, though, did you?
No, again, it just depends on the situation. I mean, we can go into that, but I don't think it would be appropriate.
Hey, by the way, go to page 2 for a minute. If you would, please read that to yourself. Let me know when you're done.
Page 2.
Yeah, it'd be the second page.
Oh, yeah, I got it. With the 2 black boxes on
Yep,
it?
there you go. Thank you.
Sir. Shoot. What's this? I think I just mixed all your exhibits up.
It's
here.
okay. We'll figure it out.
Okay.
If you can just look at the one that's got those 2 boxes on the side and
Yes,
just read
sir.
that and let me know you're done.
Okay, sir.
Okay, and just kind of clarify for the jury, this is a text exchange on Signal between you and Ian Paddington, is that correct?
It says signal messaging. I don't know if it's on Signal or is it appears to be directly between the 2 of us.
And who is Ian Paddington?
He was actually leader of, it was another militia. I'm not sure. It's not ringing a bell exactly which one he was, sir.
Okay, actually, Adam, I'm gonna need you to kind of go up at the top, if you will, and just, if you can just give me the full page, let me see what that looks like. And you can read from your page there, but Mr. Paddington messages you, and then again, this is August 13th of 2020. Hey, was your group going to Adams trainings near Cadillac? And your reply was, not sure yet. And then he messaged you, and this is all on the 13th of August of 2020.
Yes, sir.
Okay, I'm asking because it sounds good. And if you guys were going, maybe give the rest of the groups an education on how good / bad it is. I know Adam's a decent dude, parentheses, very driven. My concern is that he's a new CO and that's a tough job for anyone. And then I think you replied, I've done training with them already. They seem to have their shit together. That's what you said, right?
Yes, sir.
And who are you referring to when you said, I've done training with them already? They seem to have their shit together.
This is the first time I met Steve Robeson's group and did a training with them.
No, you're the whole conversation here in context.
It's referring
Null
to it
is
farther down the line. Oh, I'm sorry.
It's okay. I understand. Mr. Wilson, the question was, who was he referring to? Correct?
right.
And Mr. Null, your answer was?
This was the first time I did a training with Steve Robeson's group in Wisconsin.
Okay, that's who you were referring to in that text message?
I believe after reviewing the whole thing, yes.
Okay, Mr. Wilson.
Okay. Well, but the message the messages that precede your response are all about Adam Fox and his group. So how do you connect Steve Robeson now to this message?
Steve Robeson's the national commander of his group. It's a nationwide group.
No, but the messages that precede your message are all about Adam Fox.
Asked and answered.
He's the new CO of the.
Hang on.
I'm sorry.
Well, Is there a follow-up question that's based on that? I mean, the difficulty is if it's or anything to witness.
That's why I'm gonna withdraw.
Okay. Is there a follow-up question?
Yeah, well, my first question is, you would agree with me that the messaging before your message is all about Adam Fox and that he's a new CEO and.
Yes, he's the Patriot 3% Militia of Michigan.
Okay. Are you sure he wasn't the CEO of Barry Croft's 2nd Continental Army Michigan Regiment?
Never heard of it before this, and he is the CEO of the Michigan 3% Patriot Militia.
Okay. Let's get back to my question. Your statement there in the box content in the middle of the page, you're telling the jury that you're talking about Steve Robeson there? Where's he mentioned in this whole thing?
The only training I had ever done at this point in time was with Steve Robeson's group in Wisconsin.
You trained with Adam Fox in Wisconsin.
Yes, he was there.
And you trained with some of the Wolverine Watchmen in Wisconsin, right?
I still do. I did not know who exactly they were. Their name Watchman was there, but I didn't spend a bunch of time with anybody there. We were running drills.
Okay, we'll get to that in a minute. And then the next message is, Ian Paddington says, Wisconsin, for sure, I think you mentioned it before, just looking to for an info bridge to get others interested in doing the same. And then you go on and say, I hear you, man. I've been talking and working with several groups from around the country. I think Adam will do fine. He's got good people with him. You felt like Adam Fox had good people with him?
After training in Cambridge, Wisconsin, and meeting all the people that were there, they seemed actually down to earth.
Okay.
Are we done with this one, sir?
Yes, sir. That was 119. Thank you. Can I have exhibit 219? These patches, and you can either look at it in there.
What exhibit, sir?
219. And you can either look at it in the book or you feel free to turn around and see what the jury's looking at. It's up to you.
Just, okay, I see them.
Okay. That patch there of yours, I don't believe in anything. I'm here for the violence. What did you mean by that?
I didn't mean anything. I just liked the statement, so I bought the patch.
You like the statement of I'm here for the violence?
No, it's just a statement.
Okay. Okay. Can I have, and we're just about done here. Can I have exhibit 48, please? 48.
Am I looking at that too, sir?
That's going to be actually a Facebook video, and we'll play it, and then I'll ask you a couple questions about it.
Sir?
You can play it up here.
Yes, sir.
Okay, Mr. Null, yeah.
Just take me a second.
Take your time.
So we're here going live here in the Capitol. We're gonna see what they have to say today about this whole shutdown order and whatever else they're trying to hide here in Michigan. Just stay tuned.
Yeah, that's what I'm talking about. People
me to not just bitch in the streets, let's bring it to the Capitol. There's a lot of people here that are hungry and they're tired of this tyrannical bullshit. People need to wake the hell up. This isn't about a fucking virus. If you look at the comorbidity, they're blowing the numbers out of the fucking water, supply. Quit being sheep and get the fuck off your ass. No, I'm Joe either. I'm not afraid to do something if it comes up.
Can I have the transcript 48T, please? I'm going to ask you a few questions about what was said there, Mr. Null.
Yes, sir.
And it's actually in your book. If you just want to read from there, it's 48T like Tango.
48T.
And 6 lines up from the bottom there, you're talking to a gentleman during that clip. Is that correct?
Yeah, I guess.
I mean, you heard another man's voice.
Yes,
right?
sir.
And you heard your own, right?
Yes, sir.
Okay. And you agree with me that he says to you, I'm not going to lie, though, if shit starts happening, I'm heading up north. You know that? He said that to you, right?
Yes, sir.
And then I think your response was, not me, dude. I'm going to have fun hunting, right?
Yes, sir.
It's April in Michigan, right?
Yes, sir.
Okay. What are you going to hunt in April in Michigan? What were you referring to there?
I don't think you actually give a date when shit goes down.
Well, but let's what do you, not me, dude. I'm not going up north. I'm going to have fun hunting. Who are you going to be hunting?
Whoever's attacking us, I guess.
Okay. And then at the bottom, you make it very clear. I don't just carry my guns for show either. I'm not afraid to use them if it comes down, right?
Yes, sir.
Okay. Can I have, I'm all done with that. Can I have exhibit 96, please? You ready? Yeah, 96, please. And Mr. Null, we're going to play this exhibit for you, and then I'll have a couple questions for you, okay?
Yes, sir. This is a video, sir?
Yes, sir.
I'm not ready.
Can you pause just for a second? Hey, Mr. Null, that gentleman next to you, who's that?
I believe it was Adam Fox.
Okay, and go ahead, please.
Love it.
Hey, Mr. Null, that's you and Mr. Fox trained together in Cambria, right?
Yes, sir.
Okay. Do you have a binary trigger on that weapon?
Yes, I did, sir.
Okay, that's what allows it to fire so quickly. Is that correct?
Yes, it fires when you pull the trigger and it fires when you release the trigger.
Right. That's something you added after you bought it, right?
Yeah, completely legal.
Okay, I understand. Okay, can I have 176, please?
Is this another video, sir?
Yeah, it is. It is. It'll be up on the screen. Thank you. And pause. This is the kill house or shoot house, however you want to call it in Luther. Is that correct?
Yes, sir.
Okay. Go ahead. Who's that gentleman?
Which one, sir?
The one right there. I should ask you to stop it sooner, Adam, but yeah, go ahead. Who's this gentleman right here?
That's my brother Mike.
Okay, and who's the young man behind him?
That would be my son.
Okay. Your son's in on this too, isn't he? This training.
In on this training, he
Yeah.
got the FGX, yes, sir.
Okay. Go ahead and play. Hey, those things that were in there, and you're in that video too, correct?
Yes, sir.
Okay, and then the things that are in you talked about yesterday, I think, shoot, no shoot, right?
I don't recall if we talked about that or not, sir.
Okay, there was shoot, no shoot targets in that shoot house, wasn't there?
There could have been, sir.
I mean, I think we saw some of them in the video, didn't we? Do we want to play it again?
If you would like.
Yeah, let's play that again. Adam. Yeah. Right there was behind that gentleman, your brother. That's a shoot, no shoot target, isn't it?
That looks like a arrow.
Yeah, it's like what you would, but it's inside the shoot house, right?
Yeah.
What's a shoot, no shoot target?
From like your 3-gun competitions, they just have a target you're supposed to shoot or you're not, and then you get penalized for shooting it.
In this environment, what's a shoot, no shoot target?
I don't recall seeing a no-shoot target in there.
Okay. Thank you very much, Mr. Null. I have no further questions, Judge.
Okay. I think what we'll do at this point, ladies and gentlemen, given that it's 12 o'clock, we'll take lunch at this point. So I'll be breakfast when we come back. We'll be on lunch until 1:30. So we'll bring them in for you, and then if everyone thinks you're ready to go again at 1:30. I'll ask you. You're free to step down, sir.
Yes, sir. Thank you.
Okay, the record can reflect the jury's out of the courtroom. Anything that we need to talk about before we take lunch break, Mr. Ralston?
No, sir.
Mr. Nutter? Mr. Sack?
No, thank
Mr. Brown?
Yes, Your Honor. There's a referee from the front of the court, wants to the soccer game that would like to chat with. His Honor.
Okay.
Wants to be able to tell the appropriate party that he's talked to you. And you confirmed that I'm unavailable between 11 and 1 tomorrow.
I would be happy to confirm that.
Then Hickok, referee Hickok, referee's call. And, it sounds like maybe he's got a message and
Sure.
pass it on.
Okay, so we'll be back at 1:30.
Thank you.
Yeah, that's fine, you sure? Sure. Mr. Mencia, are you going to be referencing any of the exhibits?
Yes, I am. Not many, John, just a
No, that's
few.
fine. I just wanted to. Okay, everyone can be seated. Welcome back, ladies and gentlemen. Hope everyone had a nice lunch hour. If you'll recall, prior to the lunch break, we had concluded the cross-examination by the people. So we would turn to the lunch break, see if there's any redirect. Mr. Mencia.
Thank you. Good afternoon, Bill. I think it's
Afternoon, sir.
afternoon, isn't it? Yeah, I
Yeah.
think so. Mr. Ralston had asked you several questions about the Wolverine Watchman in Cambria. Do you recall those questions?
Yes, sir.
And you had listed some of them off, correct?
Yes, sir.
Okay. Now, trying to put this in context, were you speaking of, your knowledge of the Wolverine Watchman, of who you knew back then in 2020, or what you've learned since that time, now in 2023?
From what I've learned from throughout this whole thing in 2023.
So back in 2020, did you know the Wolverine Watchman, any of the individual members?
I've heard of the group, but I did not know who was in the group.
Okay.
I don't know if that answers your question. or
Okay.
not.
And you were asking questions about Cambria. Who were you trying to network with at Cambria?
I was trying to network with Steve Robeson.
Okay. And now we have reviewed some of your text messages. They've been up on the screen, so to speak, with E&P about Adam. And I think we saw a quote that he had good people with him. Do you remember that?
Yes, I believe I
Okay.
said that, yes.
Well, who were you talking about in reference to Adam had good people?
Again, Steve Robeson was his national commander, so.
Okay. So when the reference was made to good people, you were referring to Steve Roberson, is that
That's
correct?
the answer.
No, it's a preface to my next question. Okay. And why were you networking with Steve Roberson?
Well, he was the national commander of a big group, and he stated multiple times he worked with law enforcement.
Okay. If I could have Exhibit 119, please. If you don't mind, gentlemen. Do you have 119 in the book there? Unless you want to turn around and take a look at those, Mr. Null. Page 2. I'm sorry. I was trying to find that right now. Do you see page 2? Or you can go ahead and look around.
Yes.
Okay.
I have the.
Okay. And what are the dates? Do you know the date of these messages? Can you read those?
8/13.
Okay. This is after Cambria, correct?
Yes, sir.
Okay. Did this ENP person, did he refer to Adam as a new CL?
Yes, he did.
Okay. And do you know what group Ian was talking about?
The Michigan chapter, the 3% Patriot Militia.
Okay. Okay, I want to draw your attention to People's Exhibit 81.
Put this away, sir.
Yeah.
You said 81?
81. Let me know when you have an opportunity to review that.
Yes, sir.
Okay. What is the date on this exhibit? People's 81.
The first page is 6/23/2020.
6/23 of 2020, is that correct?
Yes, sir.
This is before the Cambria FTX, correct?
Yes, sir.
Was the Cambria FTX on July 11th of 2020?
Yes, sir.
So this would be a couple weeks before that, correct?
Yes, sir.
Are you familiar with this Facebook page?
Yes, I am.
Okay. Who was the first person who posted on this page?
Roby Steve.
Who's that in reference to?
Steve Robeson.
Okay. And could you kindly read the first post on that page? Slowly and loudly for the jury,
Yes, sir.
please.
Welcome, Michigan chapter of the 3% Patriots, of the Patriot 3%ers United States. You men and women are the epitome of patriots and lead by example. Adam Dean Fox, has been voted by National to get the ball rolling as CO and will support XO and appoint XO and so forth. You guys rock. Can't wait to train with y'all. We will regain our republic.
I'm going to stop you right there. Is
No,
there?
I asked the whole thing.
No, we're going to read the whole thing. It's just I know the jury's trying to read up there. And if we could get a zoom in, Judge?
You can read the whole thing.
Can we get a zoom in on that? Yes or no?
If the agent wants to zoom in, that's fine. So he's gonna read the whole thing at once.
Oh, we're going to do it.
We'll start over and he'll read the entire thing.
By all means. Can you hold on a second? Can you zoom it? There we go. Yeah, go ahead. Please read the whole thing all over again.
Yes, sir. Welcome, Michigan chapter of the Patriot 3%ers United States. You men and women are the epitome of the patriots, or of patriots, and lead by example. Adam Dean Fox has been voted by National to get the ball rolling as CO and will appoint XO and so forth. You guys rock. Can't wait to train with y'all. We will regain our republic by whatever means necessary. Guns up, and long live the republic.
Thank you. Were you ever appointed in XO?
No, I was not.
Did you go to Luther or Cambria as the 3% member?
No, I was not.
And that would be the National 3% Patriots member.
No, I was not.
Did you consider yourself a member of the National 3% Patriots?
No.
Did you consider yourself a member of the Michigan 3% Patriots?
No, sir.
Why not?
I had my own militia, Michigan Liberty Militia.
Did you participate with this group on Facebook?
Rarely, yes.
Did you on 7/14 of 2020?
Yeah, is it okay if I?
Yeah, please. We're still in Exhibit 81.
7/14, sir?
7/14 of 2020.
Yeah, I respond.
Are you there on 7/14 of 2020, sir?
Yes, sir.
And this is part of an exhibit that's been admitted, right?
Yes, sir.
Can you read the post to the jury, please? Oh, wait a minute, hold on a second. There we go. Thank you. Go ahead.
Which one would you like, sir?
Let's start from the top, I guess.
Okay, sir. I'm trying patriots. 5 sheriffs, only one willing to see what I have documented to charge with. They agree, but won't do anything to help us. Maybe get this meeting and see what's really up.
Okay. And I think there's another post by Mr. Molitor and then Bill Null again down at the bottom there, right?
Yes.
Okay. So how did you respond to this?
I've got a couple personal cell numbers for sheriffs. I'll call them tomorrow as well, but IDK if they will do shit either.
Okay. And if you just turn around and let the jury know, what box were you reading from? Is the bottom one there?
Yes, the bottom box.
Okay. Is it possible to zoom in on that one? So you were willing or forwarded some personal cell phone numbers for sheriffs to Adam Fox. I'll withdraw. What did you mean by that post?
That I had cell phone numbers for sheriffs.
To give to whom?
To give to Adam Fox or I would call them.
Okay. And what do you think Adam was talking about?
I'm going to object as to what Adam was thinking about.
Well, what did you believe?
Hang on.
Sorry, Judge. No, I'm just gonna ask a different question.
This is named for speculation.
Okay. And what's the date of this again?
7/14 of 2020.
Okay. This is just 3 days after the Cambria FTX, correct?
Yes, sir.
You're talking about forwarding on sheriff's phone numbers to Adam Fox. Is that correct?
Yes, sir.
Okay. In this particular post regarding sheriffs, are you talking about any type of violence or anything like that?
No, sir. It appears to be a legal recourse.
Okay. A non-violent recourse or a violent recourse?
He's already answered the question.
I'll withdraw. Drawing your attention to your FBI interview.
Can I put these away?
Sure, please.
Yeah, I don't remember which page was which. But
That's all right. We'll straighten it out. So just drawing your attention and moving on to your FBI interview. And we've heard the back and forth a little while ago with your answers, I think with Special Agent Platts, or if I'm saying that correctly. Were you answering the FBI questions based on only the knowledge of what you'd learned prior to getting in UC Mark's car?
no.
Okay. Well, what did you base your answers on when you were talking to the FBI on October 7th of 2020?
The weekend in the car ride, the Circle of Trust meeting.
Okay. Now, Mr. Ralston had addressed how, I guess, is it serious you took Adam's plan before the Circle of Trust meeting? Do you recall those set of questions by Mr. Ralston?
Yes, sir.
Okay. Why didn't you take Adam seriously until the Circle of Trust meeting? And I'm making reference to the afternoon of September 13th, that's Sunday. Why didn't you take Adam seriously
until the circle of trust meeting?
Well, Adam just, like I said, he ranted about everything, but the level of participation by Steve Robeson in that meeting concerned me.
That concerns you?
Yes, it did.
Judge, can we approach him?
Ladies and gentlemen, we're going to excuse the jury for a few moments. I'll rise for the jury. Okay, doors closed, jury's out of the courtroom. Mr. Ralston.
Judge, mid-trial instructions aren't prohibited. In fact, they're very appropriate at times. And based on, it's been pervasive during the course of the trial. And it's obvious that the examination, the redirect of Mr. Nunzio is centered solely on Steve Robeson. He's going to bring him up as many times as he possibly can, not because it's really a highly relevant fact within the case, but because he's trying to gain headway with the jury on, he's trying to circumvent the court's order that, entrapment's not relevant, it's not an issue. And what I'm asking for now is the court to read to the jury the entrapment instruction that's going to be given in final to the jury to inoculate them against this kind of end around.
Mr. Nunzio or Ms. Nunzio?
May I respond, Your Honor?
Sure. It's okay, I can, whatever's comfortable.
We want everybody to hear it, Judge.
Okay.
In order to argue entrapment, you would have to argue that our client did something wrong. Our position has always been that our client has done nothing wrong. This entire trial has revolved around whether or not my client knew and understood what the plan was. There's been several questions about, you've heard Adam Fox say this earlier, you've had Adam Fox say this earlier. It's relevant and it's important to understand what Mr. Null knew and how seriously he took things based on other people's participation. As much as the people have brought up that this is Adam Fox's plan and that this is Barry Croft's plan, there are lots of other people who were involved in this plan. We have laid out during our examination whether or not Mr. Null thought that Adam Fox was a serious person, if he took him seriously. His answers have been, no, I did not take Adam Fox seriously. I thought he was always talking about crazy hypotheticals, things that didn't matter. We've laid out during our direct that he considered Steve Robeson a serious individual who worked with law enforcement. It's up to the jury to decide whether or not Steve Robeson's involvement, outside of the fact that he is a federal informant in this case, if that participation, this person who he finds to be a credible person is involved in this group, who's now talking about things after this alleged surveillance, after the people have said that Mr. Bill Null has committed these offenses, for him to determine whether or not, okay, now that this person is involved, this person is actually participating in these conversations, now I know that this is serious because he's an individual who I've taken serious, an individual who says he works with law enforcement to stop sex trafficking. If he is part of this, that must mean that this is now serious. And now, for me, I have decided that this wasn't just crazy talks about Adam Fox. This is something that this group is actually planning. I think that is relevant to the jury. Again, we are not arguing entrapment. We're not arguing that the government made him do anything. We are saying that the government was involved, but even though they were involved, my client still did not commit a crime.
Mr. Seibert?
Judge, I concur 100% with her. I can't add anything to it. It's great.
Mr. Barnett?
I just think the timing right now is not right, as far as Mr. Polish, or he's not committed a crime, and I feel the same way Ms. Nunzio does about entrapment, generally being for guilty defendants. I think we think all facts should come in. There was ARC and SOPI supervision and the immense size and far-reaching nature of this case when it comes to the material. I mean, how do they look at material unless they hear all the facts? So I think it would, right now, cause a problem to the jury. The court wishes to do this as part of the standard and or additional jury instructions. I don't think it should happen right now, just as a result of that question that we feel the government did obviously try to manufacture and instigate criminal conduct, and they enhanced a lot of things, but it didn't apply as here because there was a citizen that was in the way of them. They buffered themselves, and we are not using that word, but we feel that the big picture, the landscape, all the facts should come in so they can see how big this thing was. There was some mistakes made, not only in testimony, but in the supervision of people that they shouldn't have trusted. And just right now, I would object.
Mr. Wilson, any comment?
No, sir.
Mr. Nunzio, what was the line of questioning going to become?
Right now?
Yep.
We're done. Honestly, that was the last question I had for him. And I was just making reference, Your Honor, to Exhibit 81. They're the ones who put this exhibit in, so we were responding to it.
I appreciate that everyone made the reads this morning and
Okay.
ready to go.
So we have no more questions.
Okay. I guess I don't have an objection to the question that was just asked. I don't think it triggers needing the entrapment. I think that, again, you can have Stephen.
Oh, sure.
So I don't have any issue with that question being answered, which I think it was. Redirect is done, and then redirect is done. I'm not going to instruct the jury on entrapment at this time. But I think, I mean, whether we say the word or not, and this is me generally speaking, I'm not referencing any particular question, I'm not referencing any particular thing quite. Whether the word entrapment is said is irrelevant to whether or not the concept is brought up. I mean, I can think of a couple of questions that don't use the word, but I mean, the phrasing that was just described of the size and scope of what the government did, I mean, that conceptually is entrapment. I mean, there's no other way in which to view it. I mean, whether or not a motion is filed triggering an evidentiary hearing because the legal concept of entrapment is triggered is a different matter of whether or not in scope and concept it is being argued factually to a jury. I have been quite clear, and the law is quite clear in the state of Michigan. Entrapment is a legal issue, it's not a factual issue. If that's where the question ended, then that's fine. There's nothing to trigger in the court's mind a need for that instruction. As I told the parties to skip ahead to whenever we talked about jury instructions on the record, because as I think everyone is aware, I kept the parties, we stayed until, I don't know, 6 or something on Friday, talking about the jury instructions, so at least conceptually we understand what they're going to be. Obviously, there will be changes based on what's happened or what may happen. But I had already let them know that my decision was that the entrapment instruction that we'll talk about is going to be read to the jury because it has been broached conceptually at a minimum multiple times, even if done artfully at times, to the point where the court felt that it needed to be expressed so that they understand that it is a legal concept and not one for them to consider. Because I have been clear on that, I anticipate that we won't have any issues going forward. I don't know how any more could pop up, quite frankly, but you know, the day is young and we'll see where it goes. So we'll consider the matter closed. When we bring the jury back in, we'll let them know that redirect is concluded, and then obviously we'll go around the room from there. Okay? Anything for anybody?
No, sir.
No, thank you.
Thank you. All right. seated. Welcome back, ladies and gentlemen. We've heard the testimony that concluded.
That's great, we have no more questions.
Mr. Cyber, anything for you?
No, Your Honor, thank you for the opportunity. No, Your Honor.
Any recross?
No, sir.
Okay. Ladies and gentlemen, that means it's time to see if you have any questions. So I know you just got back in here, but what we'll do is release you to the jury room. You're going to get really good at the up and down. And then if you could just let us know either way if you have any questions. If there are some, obviously send them out so that we can review them ahead of you coming back to make any determinations that we need to. Okay? All right. Thank you, jury. Okay, everyone can be seated. The record can reflect the jury's out of the courtroom. We'll just wait a few minutes. If folks are free to stand, sit, whatever you wish, and sir, you can step down if you want while they're deciding.
Thank you, sir. Okay, you can have seats with us now. So we're back on the record that the jury is still out of the courtroom. They sent out their prospective questions. The first of which is, how did you see Mark know where to go since it was a dark, rainy night and he was unfamiliar with the area?
That seems to be an appropriate question.
No objection.
Objection or no objection?
No objection.
Sorry, I just couldn't hear.
Sorry, Judge.
No, that's okay. You want to protect people, why not be a cop? I think that's an
No
appropriate question.
objection.
Why use the word recon if that's not what you're doing? I think that's an appropriate question.
No objection.
After Dublin 6/6/20, when Croft and Fox were ranting about becoming terrorists, why did you not call the police? I think, well, he answered the general question of why not call the police. I don't know that it was in specific reference
It was
to
not
that
specific.
time frame, so I think that's still an
No
appropriate
objection.
question. And then the next part of that is, or at least get away from them. I think that's an appropriate question. What do you mean world came to an end, which I think was in reference to one of the messages that was posted. I think it was world coming, I think it was the world was coming to an end or something.
They referenced it, Your Honor, saying, if the world came to an end.
Yeah, okay. And then what does Ragnar stand for?
No objection.
Do you have a gun range or shoot house on your property? I think that's an appropriate question. If so, does the militia meet there? Also an appropriate question.
Are you saying appropriate, inappropriate?
Appropriate.
No objection to either one.
Okay. You don't know where you're going, but you get in a car with a ranking man. I think that's a leading question, but certainly appropriate.
No objection.
Okay. You seem like a strong, capable man. Why did you not question where this car ride was going and why you were going there? That's an
No
appropriate question.
objection.
After Luther, why did you still have text with Fox? And then also, why not break away from him? I think all
No
those are
objection.
appropriate questions. Anybody disagree?
No objection.
Mr. Walton?
No objection to any of them.
Okay.
What was the last one?
As a two-part, after Luther, why did you still have text with Fox? Text, I assume text messages, but it's text with Fox. Why not break away from him?
Thank you.
Any objection to those being asked?
No objection. No, you're not.
Okay. All rise to the jury. Okay, everyone can be seated. I'm just gonna stand up because if I sit down, I'll have to see at the top of your head, sir.
Yes, sir.
First question is, how did you see Mark know where to go since it was a dark, rainy night and he was unfamiliar with the area?
I don't know how Mark knew he would go. I don't remember if he had his GPS on his phone or how, but he just goes around. I don't know if it's that.
Okay. I mean, the answer is, I don't know.
Oh. Okay.
You might be a cop.
I always respected law enforcement to a point, but I never wanted to be I didn't want to be a cop. The decision to become was due to wanting to stand up for the people outside of law enforcement. When you see bad things happen in your community, it doesn't have to be law enforcement that stands up and helps the community. Again, we want to be involved in our community.
Okay. Why use the word recon if that's not what you're doing?
When I had stated recon, I think it was in the car ride. That was in the middle of me, I guess, bitching about my government, and I didn't actually do any recon. I went for a car ride. So I don't know why I actually used the word recon when I'm also in the same sentence bitching about the government and the ordinances on my property. So I don't know why I used the word recon.
After Dublin 6/6/20, when Croft and Fox were ranting about becoming terrorists, why did you not call the police?
In that situation, there was two people ranting. There's 15 other people or more there. I didn't take what they took as serious. When you're talking to the entire group, they're talking about communications. The one guy's talking about going back to school to become an educator so he can teach history class on the Constitution. Not everybody said crazy shit, but I didn't take them seriously. There's only 2 of the entire group that are actually freaking out or running their mouths about crazy shit.
And the second part of that is, or at least get away from them?
Again, when I was networking with the group, it wasn't specifically Adam and Barry. There was, again, multiple people in that group. There was, like, again, Steve Robeson, there was Jeremy Heater. There were several other people that I actually talked to outside of that. Barry Croft, I met him a couple times, and there might have been Facebook conversations or whatever, but I mainly networked with other people outside of that group as well. So them 2 specifically were not who I was networking with.
Okay. And what did you mean? There was a message that we saw, I think, in the words "world came to an end" were included in it. What did you mean by that?
I'm not sure exactly what one we're talking about.
You know which exhibit it was, Mr. Null? Sorry, I didn't mean to interrupt you.
I don't, Your Honor, I'm sorry.
I don't remember off the top of my head.
Was that a question that I said, or was that an answer I said, or was that an exhibit?
I thought it was a message that was.
Or was it a text message?
I think it was his testimony, when he said, he was explaining, that if the world came to an end.
Oh,
I
okay,
think
so
it was his testimony today.
it was me. I probably said if the world came to an end.
Okay, then what did you mean by that, Chris?
If I'm recalling what we were talking about, like our militia or whatever, we're preparing for, like, if total anarchy happened or natural disasters, there is nothing else and it's just you against the world. Like, there's no more law and order. I don't know the best example for it, but like if you have a natural disaster in Texas, there is no power, there's no nothing. To me, that's like the world came to an end for those specific people, or power outages. There could be a million reasons, but if the world came to an end, we always want to be prepared. You want to know if you have neighbors or you have help or how to survive certain situations.
And then what does Ragnar stand for? I think that was the word that appeared in front of your name on one of the Facebook profiles.
Yes. Ragnar was just, it's a name from from a Viking or a Viking show. The reason why I had to put Ragnar on there is just because my Facebook page has been taken down, I don't know how many times. If I used B Null or Bill Null as my Facebook, when I restarted a Facebook page, it instantly was banned and cut off. I ended up finding out if you put Ragnar in front of Bill Null, I was allowed to have it. So that was, I don't know how many Facebook pages in that Ragnar got put on there, but I still left my name Bill Null so that people knew who I was.
Do you have a gun range or a shoot house on your property?
No, not on my property.
Okay. The next question says, if so, does the militia meet there? So if you don't have one, then I suppose they couldn't. You don't know where you're going, but you get in a car with a ranting man? Question mark.
Yeah, I don't know. Again, networking, getting to know people. Probably stupid as hell on my part, but yes, I did that.
You seem like a strong, capable man. Why did you not question where this car ride was going and why you were going?
I don't know. We went for a ride, again, getting to know people. I don't know exactly where we're going. A bunch of ranting people in the times that the country was going into. We're just, I don't know. We were in the middle of it. As far as like they say, everything was just, it was a crazy time. So I don't know exactly how to answer that question.
Okay. After Luther, why did you still text with Fox? And then the second part is why not break away from him? So for the first part, after Luther, why did you still text with Fox?
The only text messages I recall from Adam Fox is, he texted me, he had texted me that Red was coming to town with gear, and I had responded, okay. He said something about, his next text was, oh, how did he put it? It was basically about going to Cambria, Wisconsin for another FTX. And my response was, I was planning on going, but I needed money. So that was basically my way out, and I was not continuing there. If there was other text messages, I do not recall having any other text messages with them after that. Them two specifically, I do remember.
Okay. And then why not break away from him if there's a further answer?
I think I had already. We had left. I'm pretty sure we were done communicating. I don't recall any other question, or I don't recall too much interact. It was just, I vividly remember them text messages. I think that was the last communication.
Okay. Any questions for the parties based on the jurors? Let me start with you, Mr. Nunzier.
No, thank you.
Mr. Seibert?
No, thank you.
Mr. Barnett?
No.
Mr. Walker?
Just one, Judge. Hey, Mr. Null. Ragnar means warrior, doesn't it?
Actually, I don't know the definition of it. Ragnar was the name of a main character on the show, The Vikings. That's where I came up with the name, sir.
Nothing else, Judge.
Mr. Nunzier?
Nothing.
Mr. Seibert? Mr. Barnett?
No.
Well, ladies and gentlemen, you have an opportunity to ask a question based on that one, but we would need to take a break anyway because I need to talk to the attorneys about scheduling. So I think what I'll do is I'll excuse you from the courtroom at this time, and then we'll just check in with you in a minute to see if you have any additional questions based on that one. And if not, then we'll talk about our scheduling things and then bring you back in the room. Okay, all rise. Mr. Null, you're free to step down.
Okay, thank you, sir. Am I coming back up if they have more questions? Or?
You would, yeah, you might as well take those with you.
Okay, thank you, sir.
Presume they won't have any questions based on that.
I hope not, sir.
You can leave that, Mr.
Yeah.
Null.
Just leave that there. Okay.
Okay, the record can reflect the jury is outside the courtroom. Let's assume that they don't have any additional questions. Any further presentation for you all?
No, on behalf of William Null, the rest.
It's hard not to get the names. You have to think about it for a second.
I was gonna say Ragnar, Judge.
Mr. Snyder, you need a few minutes, I
I
assume?
need a few minutes to
Okay.
talk to my client.
1 second. Okay, then why don't we take a break, take as much time as you need, and then once you know what you're doing, if all the attorneys can just come see me so that we can work out what we're gonna do schedule. Thank you. And we'll be recess until that time.
Thank you.
Yeah. They're also.
Judge,
Yep.
do we need to put things on the record before the jury comes back in?
Oh, yeah, yep.
Okay.
Yep, everyone can be seated. The record should reflect that the jury is outside the courtroom. Mr. Renfield, I think I asked you if any further presentation for you.
No, we have William Null, we rest, Your Honor.
Okay, and I'll allow you an opportunity to do that.
Thank you.
Mr. Cyber, let me go to you. Any presentation for you on behalf of Michael?
No, Judge.
Okay. Are you okay if the court asks him to describe some general questions relative to testifying?
We'd be free to have you.
Okay, so Mr. Null, and again, for the purposes of the record, this is directed towards Michael Null. So do you understand, as you've seen, you do have the right to be a witness and testify on your own behalf, do you understand that?
Yes, sir.
You understand that the process would be that obviously Mr. Cyber would do a direct examination as you've seen, and then Mr. Ralston would have a chance to cross-examine you, so do you understand that process?
Yes, sir.
And have you discussed with Mr. Cyber the, I guess, cost benefit or strategy relative to whether or not you want to testify in this case?
Yes, sir.
Do you have any, or do you need any additional time with him relative to that?
No, sir.
Do you have any questions for me about that process?
No, sir.
And have you made a decision as to whether or not you would testify in this case?
I have,
Okay, and what is that?
I am, not testified.
Okay, and I don't think I specifically mentioned it, but you understand that when you don't testify, the jury can't use that against you in any way, and actually there will be an instruction indicating that they cannot. So you understand all of this?
Yes, sir.
Okay, and that played into your decision?
It was weighted decision,
Okay.
that made it, yes, sir.
Okay. Any additional questions that you want me to ask?
Just briefly, Mike, you're happy with your representation? Yes, sir. And you're making this choice free and voluntary? No case force in your hand?
No, sir.
Okay, thank you.
Mr. Cyber isn't pressing you.
That's up to you.
Okay, and Mr. Wilson, let me go back to you. Do you anticipate any rebuttal?
No.
Okay, so what we'll do, we'll bring the jury back. Mr. Nunzi will allow you to rest. Mr. Cyber, you reserve your opening. Will you be waiving that?
Judge will be waiving that since Mr. Null will not testify.
Okay, then I'll go to you to ask if you have any presentation, and then I'll ask if you're going to waive the opening since you reserved it. Mr. Ralston, I'll go to you relative to rebuttal, just so the jury's clear on all of that. For everybody else, the plan going forward for this afternoon would be to release the jury at that point. Well, I'm going to explain to them that tomorrow we're going to begin closing arguments and sort of the mechanical process behind that, so they're aware of that. But they would then be released. The attorneys and I will stay, and we will be on the record for everybody just talking about jury instructions. We were able to have a significant portion of that discussion, I think, on Friday afternoon is how I'll phrase that. I don't know that much has changed, but we'll obviously go through all of that, address all of the objections that were made when we were making the argument, so to speak, in private, I guess, but that way there's a record of it. I wrote down notes on Saturday morning, so I think I got most of it, but obviously we'll let parties place any additional objections if they wish. The other thing that I'm going to ask the parties to do this afternoon is to ensure that we have all of the exhibits that were admitted ready to go, so that it is on, that they are on the clean computer ready to go. If there's any paper copies that need to be provided, just basically so that whatever is going to go to the jury, everybody agrees it's the proper set of things and that it's ready to go once they look at the case tomorrow. Okay? Anything for anybody before we bring them back in?
No, sir.
No, thank you.
No, thank you.
Are we gonna have access to the projector, or I just might have one little thing pop up during closing? I just wondered if what needs I need to do that. I haven't.
You would need to ask the Attorney General's office very nicely, and I'm sure they will come.
Thank you.
For the record, that was simple, sorry, that's something I know that doesn't come through sometimes. Anything else we need? Okay, all rise for the jury. Okay, everyone can be seated. Welcome back, ladies and gentlemen. Mr. Dunstan, I'll go back to you. Any further presentation on behalf of William Null?
No, Your Honor, the defense on behalf of Mr. Null, respectfully arrested this time. Thank you.
Mr. Seibert, will there be any presentation on behalf of Michael Null?
Judge, we'll be waiving our opening and we will be resting our case. Thank you.
Mr. Wilson, let me go to you. And ladies and gentlemen, I think I've explained this before, but because the people have the burden, just as we've seen when the parties are asking questions, there's direct exam, cross exam, and then redirect. Because they have the burden, people are allotted an opportunity for what we call rebuttal. It's just if anything is presented in the defense case that they wish to rebut, they have the opportunity to present such evidence if they so desire. Mr. Ralston, will there be any rebuttal evidence?
No, sir.
Okay. So, ladies and gentlemen, what that means is the evidentiary portion of the case has been completed. You'll recall from when I was explaining the process of the trial, the remaining portions for you are the closing arguments from the attorneys and then the instructions for the court. And then the unfortunate part of having to excuse the few of you to get down to 12. So we're not going to start closing arguments at 3 o'clock. I want to make sure that all of those are done at the same time and not have to take a break, given the expected length of those. Plus, the attorneys really can't fully prepare those until they're aware of all of the evidence that's going to come in. Also, with the instructions, we need to finalize those. You've heard them called the final set of instructions. And you may wonder that if we take all of these breaks outside of your presence, why can't we do that before now? And the answer is that because, quite simply, we need to wait until all of the evidence is in, because that can affect what the final instructions are. So what's going to happen in a few moments is I'm going to excuse you for the day and have you come back ready to go tomorrow at 9 a.m. and we'll begin with closing arguments. We have some work to do yet this afternoon about those instructions, but I want to give you sort of a layout of what it looks like tomorrow. So everybody, meaning all 18 of you, will be here for the closing arguments. All 18 of you will be here for the instructions. At the end of the instructions, you've heard us say a number of times that the final jury who will decide this case will be 12 of you. So what will happen is much like when the clerk drew your names to call your numbers to put you in the jury box back in however long ago that seems when jury selection was, she will draw 6 people at random. Those people will refer to them as alternate number 1, 2, 3, 4, 5, and so on. And those 6 people are not off the hook. They are still on duty. What will happen is there will be folders for each of you to put your notes and everything in. I'm going to give you some paperwork. Also, what you're going to do is write down your receipt number, your name, your telephone number, because even though you've been excused from the jury and are an alternate, you are still on duty, so to speak. Because until the jury has reached a verdict, something may happen in an emergency, could happen during deliberations. If somebody were to have to leave, we would have to have alternate number 1 come back if it's 1 person and then start the deliberation process over again. Okay? So for those 6 who are excused, they still couldn't talk to anybody about the case, do any research, any of those things. So part of the reason for the phone number is to be able to call that person to let them know once they are released and the jury has reached a verdict, et cetera. And then for the other 12 who are deliberating, the clock is yours after that. There's no right or wrong answer in terms of time. The deliberations will last until they last. My normal policy, we've been keeping roughly the 9 to 5 schedule going. So generally what I do, let's say we get to 4:30 and the jury is deliberating, I'll usually bring the jury out. At that point, the first thing that you'll be instructed to do is choose a 4-person. At that point, all of the communications will go through the 4-person and just say, we can stay later, we can go beyond 5, end at 5, sort of leave it up to you at that point. Okay, but that's sort of a general playlist of how tomorrow is going to happen. What I'll do is excuse you at this point. If you want to go back to the jury room, let's just wait a couple of minutes to see if there's any questions from anybody about that. If there's not, you're free to leave just like we've been doing kind of at the end of the day, see if there's any questions on, for witnesses. So if there are no questions, you're free to go. If there are, we'll address those before you. Okay, all right, the jury. Okay, everyone can have a seat. Number we'll just be short break, just to get any questions about it for tomorrow, we'll break. Before we go into further discussion, we'll be off for a second. Okay, perfect. Okay, let's go back on the record. The jury is outside the courtroom and they're leaving for the day. And if I understand correctly, obviously for closing arguments, Mr. Olson will go first, and then it's Mr. Barnett, Mr. Nunzio, and then Mr. Seibert.
That's right, Trevor.
Okay,
That's fine.
let's talk about instructions. Okay, I've handed to the parties the proposed verdict forms. I did a separate verdict form for each defendant, each of the counts. One copy of each of those three has been provided to the council, and then the respective verdict form to the respective attorney for each individual defendant. The verdict form is easiest, so we'll start with that. Mr. Ralston, any objection to the verdict forms as prepared by the court?
Is it the same as we got on Friday, Judge? I think
It is.
Yeah, no objection.
Okay, Mr. Nunzio?
On behalf of Bill Null, no objection.
Mr. Savage?
On behalf of Mike Null, no objection.
Mr. Barnett?
We have Barrett Collins, or no objection, Your Honor.
Okay. Actually, since these are going to change, does anybody want additional copies? You guys?
Sure. We'll take it in addition.
I got one left. You guys do it. Sure. I'm tired. Sorry. Okay. Oh, I lied. I didn't keep one for myself. Never mind. Thank you. Good. Okay. So the first part, and what I'm going to do is try to summarize the discussion we had on Friday. So if during that discussion I note that a party objected, that either for the purposes of the record is to be considered them making the objection so that any objection is preserved. If parties would still like to make any objections beyond that, that's perfectly appropriate. But just so the record is clear on that, because I wasn't trying to keep people around on Friday, I'm not going to hold that against the parties making a clean record. So the first part I would note is that several of the instructions by the court, so 3.2 is an example. Well, first of all, any objection to 3.1, that's the standard instruction.
No.
No objection. No objection. No objection.
Okay. For 3.2, the parties will notice, and I let them know, if it says modified, given that we have 3 defendants in this case, the court modified it. So, for example, the second sentence of the first paragraph now reads, this means that you must start with the presumption that each defendant is innocent as opposed to the defendant. And so if the instruction says modified, 3.5 is another example where for the 5th paragraph, it says the lawyer's statements, making lawyers plural and the singular, those are the only modifications that the court made to those. So any objection, how about this? I'm just going to go through them, and if there is not an objection, or if there is an objection, somebody can say it, okay? So 3.2 is one we talked about. For 3.3, the instruction for William Null was prepared because for Friday, we did not know at that time, so that one would come out. The only 3.3 then that the court had proposed would be for Michael Null, and that one was modified to include the name just so that it was specific to that individual, so that's why that one was modified. Mr. Senator, any issue with that version?
No, Judge, I've read it, I like it.
Okay.
So far, at least.
And 3.5, the only modification there is.
Nunzio, no objection.
The only-
Record's gotta be clear.
The only change to 3.5, again, was the, I think lawyers became plural, was it 3.6, 4.1, 4.5, and 4.5 is only paragraph number 1, not paragraph number 2. 4.7, 4.9, 4.16, and again, this one was modified simply to make it plural. 5.2. 5.3. 5.8A, and this one, the title was simply changed so that after the title of the generic model instruction, I just included Eric Moller's name since it only applied to him. That way it was specific. But Mr. Barnett, I don't think we talked generally about the instruction, but that's the one that I prepared based on our discussion. Any issue with that as far as you're concerned?
Sure. It's fine. Thank you very much.
Mr. Ralston, any issue with 5.8A based on what I prepared?
No, sir.
5.11 and 38.3A. So let's talk about some of the things specifically relative to this.
Which one, Judge?
We're on 38.3A now, and so I want to talk about a couple of the concepts that go with this. So the first is, I had already made the determination and ruled that the board personnel can include oneself. The people submitted a version of this instruction. So to make the record clear, in the motion, and it was entitled, is the people's motion for special jury instruction on the material support element of providing material support for an act of terrorism and on venue. Page 4 lists the paragraph that they were requesting. It's the, I've never understood why the jury instructions are numbered like this. It's the second paragraph, but it begins first and then continues with the sentence. This would be the paragraph where it lists the various forms of support that can be provided. There are some in the statute, and then as was noted by Ms. Nunzio, on the instruction itself, the use note indicates, it's the first use note, indicates the forms of material support listed here are found in NCL 750.543 lowercase b, parentheses lowercase d. The court may select from those according, I think it's supposed to be to the evidence, but it says the court may select those according to the evidence, or may add other forms of material support according to the charges and the evidence. So the court already ruled that personnel can include oneself. So part of the requested definition for the people, when the word personnel was listed in parentheses, were the words including oneself. However, they also requested a special instruction that the court modified, but I did think it's appropriate to give, based on my ruling, a special instruction as to the definition of personnel. There's the submitted instruction read, the definition of the word personnel as found in the jury instruction for providing material support for an act of terrorism includes providing oneself. The court made the determination that relative to that language, it should read, providing material support for an act of terrorism can include one providing oneself. That was objected to by all of the defendants, so that is preserved. And specifically, Mr. Barnett also asked that basically the full instruction as generically, as it is generically written be given, so to avoid confusion. Do I have that correct, Mr. Barnett?
You do, and I just wanted to add one extra argument on the personnel.
Sure.
The court's ruling. Just in criminal law, if someone's present, and typically they're not guilty by presence, and I'd just like to raise that again as a reason to kindly not include personnel and or this additional. I just want to put that on the record. Because case law, if you're present, you're not guilty typically, and I think most against that.
Okay, Ms. Nancy?
I echo what Mr. Barnett says, and in fact, I think we would request the mere presence jury instruction be given to the jury to kind of cure any issue as it relates to that. But again, just so the record is clear, on behalf of William Null, we are objecting to the court's revision of the term personnel and the echo what we've continually said about the federal.
Mr. Cyber, I assume you concur.
Judge, we agree with Mr. Barnett. We also object, just like the Nunzio law firm. We believe that the instruction is inappropriate and it goes outside the court rules in the case law.
Okay.
Otherwise, we all stand pretty much together.
Okay, Mr. Barnett?
If you didn't state my position correctly, I just wanted to say that.
Oh, okay.
Thank you.
Mr. Ralston, anything for you?
No, sir.
Okay. Well, the court already made its determination, and I indicated why, but certainly the objections are preserved relative to personnel. So that instruction is in the stack, I think.
We'll be giving the special instructions as they requested.
We'll look back. I think I got that. Yeah, I added it to the end of the list.
Thank you.
Yep. And the people also provided a special instruction, the next topic, so to speak, regarding entrapment. We did have a little discussion about that this afternoon. And the language that was supplied by them, I'd also note that specifically for this special instruction, they did file a separate motion previously, or a memorandum of law, and then they filed a subsequent motion basically restating the need for it in their opinion, and provided as part of that motion the instances in the case that they felt warranted the instruction, at least up until that point, because obviously once it's filed, there's nothing else that can be gathered. And if I think it's stating it correctly, well, first, the language for the instruction that they proposed comes from the case of People v. Patrick. That's 178 Mishap 152. And I think what is quite clear is, despite probably more research from the Attorney General's office beyond their brief, research by the court, research by the other parties, there are no other cases really that discuss a special instruction other than the way that I would describe the vast majority of them. I'm not going to say all, but the vast majority is that the appeal is, in the appeal, the defendant is requesting or saying that the jury should have been instructed on entrapment, and then the appellate court, whichever level it is saying that it's not a factual issue for the jury to decide, so no instruction needed to be given. That's how I guess I would summarize the case law. The court, I think, modified very slightly the requested instruction from the people. And I don't know that I asked the official position for everybody, so I think I'm going to go around the room for you all. Ms. Nunzio asked for the special instruction for entrapment.
We object, and I echo exactly what I argued earlier today at the people's request for the entrapment instruction given during trial. I do believe that if the court does give the entrapment instruction, it could potentially completely confuse the jury. As I've stated, our theory of this case is not that my client did anything, that my client did nothing wrong. And in doing that, we had to explain certain actors and how he perceived them. And based on his perception, when did Adam Fox's plot become serious to him? I do think that giving this instruction would confuse the jury and could ultimately interfere with his right to present a defense, because if you're confusing the jury about whether or not they can consider who he thought was a serious individual, and now that they are participating in conversations, I think it could confuse the jury, and they might disregard those individuals. And I want to make this perfectly clear. If there were other individuals that my client thought were serious, credible people who were not involved with the FBI, who were making statements like this, the argument would have been the same on our behalf. It's not our fault that certain individuals were FBI agents or FBI informants. So our argument has never been, this is the FBI, this is all their thing. Our argument has always been, I thought this person was credible, and because they were talking about it, that's when I was like, this is something I don't want to be a part of. And I think that this instruction will confuse the jury on that. Thank you.
Okay, Mr. Simon?
Thank you, Judge. Judge, we haven't alleged entrapment at all. Matter of fact, we've alleged he's not guilty. Whole heck of a lot different. Entrapment requires, like Ms. Nunzio said, requires you to admit that you engaged in a wrongdoing. My client did not engage in any wrongdoing. He didn't even know what was going on. So to be honest with you, this instruction is not needed on behalf of Michael Null. Ms. Nunzio is correct. This instruction will confuse the jury because it alleges to them that if they know what entrapment is, that the parties or a party is making an argument that they engaged in a wrongdoing that they knew was going on. And once again, we held from the beginning, not guilty, we didn't do anything wrong. It's a heck of a lot different. They're way different on the scale. You go 0 to 100. There's nothing in between here. The entrapment instruction alleges that we knew and that we engaged in it. It's over on the 0. We're on the 100% innocent, not guilty. So we would ask that you get rid of this instruction. I go back to what my father always said. If you're gonna open your mouth and speak, then it needs to have something. When the court speaks and adds this special instruction, it does nothing but confuse. Then we're claiming it's way over here, and we're standing there over there. We're not even looking at entrapment. We don't care about entrapment because we didn't do anything wrong. So we ask that you throw this instruction out.
Your Honor, we, on behalf of William Null, we join Mr. Cyber's argument with respect to it implies, infers, conveys to the jury that we are admitting guilt for purposes of the court to give the entrapment instruction. Therefore, if the court's giving entrapment instructions, the court is telling the jury that they have admitted to wrongdoing, denying them due process and rights with respect to what co-counsel said, denying us the right to present a defense. So we again echo those words. We join Mr. Cyber.
Mr. Martin?
Thank you, Your Honor. I'm going to incorporate by reference what I said earlier, that the Americans made to the extent they would apply to Mr. Monitor's situation. He's got no real direct involvement at the head with the state actor. I think it may confuse the jury possibly in the defendant's favor. So I think this might be a mistake. I would ask the court to not cause any confusion. If at all possible, I recognize what the court stands at this point and see the likelihood of this coming in, but we will just formally object on the record and warn that I think this could be confusing and could go either way.
Would the court consider an additional modification to the entrapment instruction with respect to the defendants in total, if there's agreement or objection, have pled not guilty and maintain their innocence and are not guilty of said offense? It's just that implication of entrapment, Your Honor, is worrisome to counsel regarding, this tacit, if not implicit admission of guilt. And that's what worries counsel.
Okay. Second to last line says, in so instructing, the court is not commenting on the truthfulness or veracity of a given witness, the quantity or quality of evidence against any defendant, or whether any of the defendants are guilty of the charged crimes beyond a reasonable doubt. And the last line reads again, those determinations are for you and you alone to make. And I read that language because the instruction for this special instruction, so to speak, came from the case that I mentioned, and the appellate court, in determining that the original instruction given by the trial court there, did note that there should be added reference to the fact that each of the defendants or the defendant is presumed to be innocent, and that's why that language was added.
If I may, Mr. Cyber, because I requested a modification, I've been instructed by co-counsel that I waive our original objection. Would the court then note for the record that we are then reasserting our request to object to the instruction? I apologize for that, Your Honor. We're now requesting that our objection be placed on the record regarding the amendment instruction.
So, and this has come up in discussion before, so I want to be clear about this for the record. If a court decides, so like if I decide, for example, that the special instruction for the entrapment issue is coming in, and then Mr. Nunzio were to say, okay, would the court consider a modification of the language to X, Y, Z? I don't interpret that, nor do I think the record should interpret that as you waiving any original objection that you had. If you are told, for example, that an instruction is coming in, and then asked for what you believe is an appropriate modification, you're doing business on behalf of your client. You're not, the court has already made the determination over the original objection that the instruction will be given in the example I just gave, right? So I don't view that as being waived, just for the purposes of the record, so it's clear. If in the discussion happens, all objections are preserved on all of the issues that we've discussed.
Thank you very much.
So just so that's clear.
Your Honor, so somewhere else I indicate that I'm $100 on it, that there it says that the defendants are pled not guilty in these instructions.
Oh, it does. I mean, the standard instruction for presumption of innocence and all of those, it's already been read by the time the court rejects this.
I want to make sure that it's covered there as well.
Sure. Mr. Nunzio, anything else for you?
No, thank you.
Mr. Cyber, anything else for you?
No, thank you. I think the court understands our argument.
Okay, and Mr. Wilson, I don't think I gave you an opportunity yet.
Nothing yet.
Okay. Well, as I indicated, I do think that based on the way that some of the testimony came in and some of the questioning, that it is appropriate. I don't think that there will be any confusion. Basically, it just removes the possibility for this consideration. And it includes in this instruction specifically that I'm not commenting on whether they're guilty or not of the evidence or anything along those lines. And the other instructions, I think, will clear up any issue relative to that. The objections are noted for the record. And then, okay, so let's specifically talk about 38.3A. We already did a little bit in terms of the objection that Mr. Barnett had. So back to the request that was made by the people. So for 38.3A, they requested that the second paragraph read this language for all of the defendants, and all three of them. First, that the defendants provided material support in the form of training, surveillance, and surveillance of an intended target is the language they used, recruitment, weapons, personnel, including oneself in parentheses, including any related physical assets or intangible property, or expert services or assistance to Adam Fox and or Barry Croft. And I detailed some of the objections that I mentioned already. The surveillance of an intended target and recruitment are words that were not in the definition provided in 750.543 lowercase b, parens lowercase d. But again, to read the use note, the court may select from those according the evidence or may add other forms of material support according to the charges and the evidence. Just feels weird to read something with typo in it. I guess I'll take each one of those individually and I'll make it clear each time, but certainly as to each of these decisions that the court made, well, I guess that's not true. Let me go through each one individually. In terms of the training, the Attorney General's office presented its theory relative to why that would be appropriate. The court felt that the arguments being made there fit more appropriately under the personnel personnel word, and so the court indicated that it would not give the word training or list the word training for any of the three defendants, given the court's mind it provide training, and it wasn't testimony to support that request. And I think that one was supported by each of the defendants. Mr. Nunzio, is that correct for you all?
That is correct, Your Honor.
Okay, Mr. Cyber
Yes, Your Honor.
and Mr. Barnett?
Subject to their objections to the initial.
Yep.
So no, thank you.
Yep, okay. And then surveillance of an intended target was requested. That's obviously a new one, and the court took a couple of minutes to think about that one. Just a couple of general definitions for that. Close watch kept over someone or something, continuous observation of a place, person, group, or ongoing activity in order to get information.
I'm sorry, I have a hard time hearing.
I'm sorry.
It's continuation of a person, place.
Continuous observation of a place, person, group, or ongoing activity in order to gather information. The monitoring of behavior, any activities or information for the purpose of information gathering, influencing, managing, or directing. So the court did believe that the word surveillance was an appropriate add based on the evidence that came in. I did indicate that surveillance of an intended target was inappropriate, so the court did indicate that the word surveillance would be included in the specific jury instruction of 38.3A for each defendant based on the evidence in the case. That was objected to by each of the defense attorneys, so that's preserved. Ms. Nunzio, anything else for you?
Yes, Your Honor. We are objecting to the additional term surveillance for several reasons. First, as this court is well aware, this statute has never been tested in our appellate court system. Second, these are brand new jury instructions. They came out this year, so the jury instructions on this statute have never been tested. Third, I don't think that there is federal case law that supports the addition of surveillance in the companion statute, the companion federal statute that we persist. So for those reasons, we object.
Okay, Mr. Side?
We support.
You support the argument of Ms. Nunzio, not the court's decision. So that's clear. Mr. Barnett?
I'm falling in line with that as well, Your Honor.
Mr. Ralston, anything for you?
Nothing to add.
Okay. Well, as I indicated, and I told the parties, I did think that the word surveillance, based on its plain ordinary meaning, was an appropriate add based on the type of case and the evidence that was presented. So surveillance will be listed for all three of the defendants. And when I say all three of the defendants, that was because what I told the parties is based on the use note of restricting the number of words that go in there, the court thought it appropriate to provide a copy of 38.3A and then for count 2, 11.34 as to each defendant. So after the title, so providing material support for anti-terrorism, hyphen Eric Molitor, and then there is a specific 38.3 for Mr. Molitor. Similarly, a specific 11.34 for Mr. Molitor, and then for each of the other two defendants, so that way it tends to lessen any possible confusion. As I indicated, recruitment was also a word that was sought to be added by the people. The court felt that given the ordinary definition of that word, that such an allegation would fall under the word personnel because it doesn't, based on the court's definition, it's not limited simply to providing oneself or possibly providing oneself, it would be other people as well. And so the court felt that that was an appropriate argument. So I think the way I would phrase it is the defendants did not object with the court's determination to not include that word. Is that correct, Ms. Nunzio, on behalf of Bill Null?
I'm sorry.
No, that's fine.
Can you repeat that?
Yeah, there was, so the court made the determination to not include that word, which I think it's fair to say the defendants supported the court's decision to not include that word.
That's correct.
Right? Okay.
I get the buzzer first.
Okay. Mr. Cyber, is that correct? Mr. Barnett, say the earlier objection is all words should be included.
Correct, Your Honor.
Okay. Mr. Ralston, anything else for the people on now?
No, sir.
Okay. And then evidence was requested by the people. Again, the court felt based on the argument that was presented, that would be more appropriate under the other words, perhaps personnel, for example. And so the court made the determination that weapons would not be listed. And again, the court's determination to not include that word was supported by the defendants. Is that correct, Mr. and Ms. Nunzio?
Yes.
Mr. Sider? And Mr. Barnett?
Yes.
Okay. Mr. Ralston, anything for the people on that?
No, sir.
Okay. The personnel I've already discussed. I think we placed the objections on the record for that one already. Anything else from anybody on that one?
No, thank you.
Hearing none, okay. And so just so that's clear, just the word personnel will be listed, not the including oneself, but the special definition or special instruction will be included. The language including any related physical assets or intangible property, based on the discussion of the review of the evidence, the court felt that was appropriate as to being listed for Mr. Molitor, but not as to Bill Null or Michael Null. So we're going to go around the room for any objections on that. Mr. Nunzio?
No.
Mr. Sider?
No.
And Mr. Barnett?
I did ask for the regular instructions.
Yep. And so that's noted. I'll consider that in the purposes here. Mr. Wilson, anything for the people on that?
No, sir.
Okay.
Your Honor, the reason I want them all in there, I think they give context, to one another. And without them, these lose context. I didn't agree with the nuncio's concept, which was to narrow it down.
Sure.
And I appreciate the court's taking time to do that. I think that context and having those other names in there, you get a flow and a feel for what you're talking about. And just have it sit there to that degree. I guess I would object that this is not in context with what the jury instruction that was agreed upon and put in place that I think we're changing it, giving it different meaning.
Okay, Ms. Nunzio?
To kind of go off what Mr. Barnett said, would it be possible to include, I guess, the standard jury instruction and then include the jury instruction as it relates specifically to my client, so that the jury can see both?
Well, my first thought is that would make it far more confusing to them, to be honest with you. But in saying that, I do note that they would have a copy of the preliminary instructions, so that may quite frankly exist anyway. But the court would make the determination that that's not appropriate for the final instructions to include what I'll refer to as the generic instruction, just for fear that it could create some confusion.
Okay, thank you.
Anything else that anybody wants to put on the record relative?
So the court is going to include the preliminary instructions with full context?
No, I'm sorry. I'm denying the request that what I would phrase as the generic instruction be included in the final set.
Okay.
Because I think that could create confusion for them. What I was simply just noting is that they will have their copy of the preliminary instructions that they were given, which includes the generic version essentially of the instruction. So I guess if they figured that out and wanted to make that comparison, they would be able to do that. So that takes care of including related to physical assets or tangible property. In terms of expert services or expert assistance, the court listened to the arguments of the parties, and based on the evidence that was presented, the court made the determination that that would only apply to Mr. Molitor and be on his jury instruction, which I think that determination, I guess, would be supported or no comment for the nuncios. Is that correct? The fact that expert services or expert assistance was not included for Mr. Null.
That is correct. We agree with that. That it should be excluded.
And then Mr. Siderest and Michael Null, same determination. Same. Okay, and Mr. Barnett, for the objections that you previously noted, anything specific to that one?
Same objection and or also to consider that the court rejected our directive verdict request to believe that physical assets or intangible property or expert services or expert assistance were in this trial enough to put in this, especially the expert services or expert assistance. He didn't have the medical expertise, and it says expert. He certainly wouldn't be qualified to give medical testimony in a trial. He certainly fancies himself as someone who likes medical information in his study. However, he didn't get a certificate. I think to put the word expert in front of that may help us, but also it could confuse the jury that there's something more there than isn't.
Anything else?
No, thank
Mr. Ralston, anything for the people on that?
No, sir.
Okay. The final request for that paragraph was, so the generic instruction indicates that once you list the forms of support, it would be, if there's two ways you can write the end, so to speak, it can be to another person, or it can be to specified people. And I think in the preliminary instruction, the court simply left it as to another person. And then the people were requesting that in this one, it read to Adam Fox and Barry Croft. And so I wrote down that was not objected to by the defendants, but let me confirm that, Mr. Nunzio.
The defense had, I believe, agreed to Adam Fox and or Barry Croft.
That's what I wrote down, but
That is correct. That's correct.
So that's correct for Bill Null, for Michael Null, Mr. Cyber,
It is correct.
and Mr. Barnett on behalf of Mr. Molitor.
I've had a chance to check about that, Your Honor. We'd like it just to stay as we have it.
To another person or to Adam Fox and or Barry Croft, because I have it as the specific people on the final set that I prepared, but it was the other way on the preliminary instructions. So I just wanted to be clear.
Understood. He was asked that it be Adam Fox and or Barry Croft.
Okay, so there's no decision there. Okay.
Thank you.
And Mr. Wilson, any comment for the people?
Nothing yet.
Okay. Just make sure I covered everything. Okay, those were all the objections that I had written down anyway. So then, based on the court's determination, subject to the objections that have been placed on the record, the prepared version of 38.3A and 11.34 as the Eric Molitor will be given. Similarly, the 38.3A as to William Null and 11.34 as to William Null will be given by the court. And then the prepared version of 38.3A as to Michael Null and 11.34 as to Michael Null will be given by the court. The special instructions we have already discussed. And discussing the next ones, the people as part of their motion also requested a specific venue instruction. Mr. Olson, I'll summarize as best I can, and Mr. Pals probably will phrase it better than I will do justice for him, but basically the venue and structure statute that was cited by the people during the motion for directed verdict, 762.8 deals with when a felony is made up of several acts, and then one of the acts must occur in Hampton County. And so the standard instruction of 3.10 would indicate that the prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about November 1st, 2019 through October 7th, 2020 within Hampton County. Those were the dates that were listed on the felony informations. The other standard instruction is 4.13. That's a special venue instruction for a felony consisting of more than one act. The language for that instruction would read, the alleged crime in this case is made up of several acts. The prosecutor only has to prove that one of these acts took place in Hampton County. He does not have to prove that all of them took place there. The people requested a special instruction, and if I'm going to summarize the argument that's made, it was that under 762.8, there is language about or acts done in perpetration of the felony to have an effect in the county. And so the instruction that they prepared included more specific language, I guess is how I would phrase it, especially relative to that. The proposed instruction for the people was objected to by each of the three defendants. Ultimately, the court determined that the two instructions that I've already read, the standard instructions, 3.10 and 4.13, would be given. And mainly that was because, while I do agree that the word effect, for example, in that specific language is not necessarily included in 4.13 directly, in the use notes, they specifically cite MCL 762.8 in its full language. So obviously the drafter of the model instruction knew that, unless there's a good reason to deviate from the model instruction or standard instruction, the court's not going to do that. And so that the request by the people for that version of the special instruction was denied, and the court determined that 3.10 and 4.13, as I just read them, will be the ones given. Mr. Nunzio, anything for you on that? Sure.
Your Honor, I do think that we will object to this specifically. I am concerned that the jury could, based on this instruction, believe if there was a criminal act in Antrim County, that the knowledge component, the knowledge element of the crime occurred somewhere else or later, that the jury would disregard the knowledge requirement. Because the knowledge requirement has to happen at the same time as that criminal act in order to be a crime.
Okay, Mr. Sutton.
Judge, we support Ms. Nunzio's position and objection.
Mr. Martin.
It was, Mr. President, Maria, or reconvening that, we object to 4.13. I know in that it does say an alleged crime. I did propose a modified instruction. If I didn't mark it up right, I apologize. But if 4.13 comes in, Your Honor, I would ask that to be consistent, that 3.10 be modified as well to read that the reasonable doubt that the alleged crime occurred on or about November 1st, 2019 to October 7th. In other words, why not have the word alleged involved with them? It just is an odd instruction that it calls it a crime, and then the next page they flip over at alleged crime. Maybe there's a good reason for that somewhere.
Sure, it was written by lawyers, so couldn't be wrong.
That's our judges.
Haven't helped us, but that's good. Mr. Ralston, any comment for the people?
No, sir.
Okay. I do think that it's appropriate to give, based on the facts of the case, both instructions, 3.10 and 4.13, as I read them. I think that any issue relative to those presented in the objections are certainly maintained, but based on the facts of the case, so those will be given to the objections are noted for the record. 3.11, that's modified because the court, as part of this is the traditional way to do things. We collect the electronics for the jurors, so phones, and we also collect any smart watches, anything that can send or receive information. So that's why that one says modified. 3.13, 3.14, 3.15, and generally I will let the parties know when I'm reading these exhibits. I tell them, for example, when I read 3.15, just as I did today, you're going to get the exhibits to take and review. So just as a heads up, I don't consider that a modification, but and then in terms of communication with the court, we will swear in Sergeant Knight as the bailiff and also the court staff member, just in case either one of them take the notes from the jury to transport them to me. So they will both be sworn in as the bailiff's or court officer. What I tell the jury is if they have a question, they simply will write the question out on a piece of paper, which they are very familiar with because they've been doing that. What I tell them is once they have reached a verdict, they will just simply write the word verdict on a note form or on a note, hand it to the court staff or the bailiff, not indicating to them what the verdict is. That will be the trigger for us to reconvene. So 3.16 will be given. And then 3.22 is because there are multiple defendants, multiple counts. That way, again, reminds them that it is consistent. And so we are at presence. We need to talk about anything else Any other requested?
So we brought that up, I don't know if Mr. Rolston has anything else or not.
Well, I won't know. Anything else before we get to that one, I want to look at it and we can all talk.
Okay, well then, no,
No others that were asked.
we have,
Is that what the court's asking?
Yeah,
okay.
because what I want, we don't have to argue them now, I just want the list so that we can go through.
We would be asking for, a special jury instruction regarding guns. There was a lot of jury questions regarding whether or not guns were legal or illegal.
Okay.
So essentially, I would like the court to instruct them that Bill Null hasn't been charged with possessing a gun, possessing a illegal gun, okay? And that cannot be a part of their determination as to what he is charged with.
Okay. Is there specific language or are you just requesting generally speaking?
Generally speaking, if the court wants me to drag something, I can.
No, that's fine, I just don't make the list, so.
Additionally, even though this court ruled that Special Agent Inflow was not giving expert testimony as it relates to his training and experience for Boogaloo ideology, extremist ideology, et cetera,
Okay.
we would be asking for essentially a modified expert jury instruction so that the jury is instructed that they can disregard what Agent Impala has stated his opinions regarding things are, because I think his testimony was akin to expert testimony, and they get to be the ultimate fact finder. So I wouldn't like it re-emphasized to them that they get to make the determination on what he was testifying in his opinion to.
Okay. Those three? So mere presence, special instruction as to guns, and then modified by one.
Just a few.
Okay.
I haven't talked with other counsel, but I do think a 440 instruction as it regards to conspiracy would be right, given that there's a lot of testimony regarding the plan, and if people are agreeing to plans and if people are not agreeing to plans. And I don't want the jury to be confused because they're not charged with conspiracy, okay? They're not charged with agreeing to do something. The people have to prove beyond reasonable doubt that a criminal act providing material support happened. I don't want the jury to be confused as it relates to agreeing to do something, because that in and of itself does not fall under material support.
Okay. Anything else? That's it? Okay. Mr. Stiver, any additional requests for you?
No, Judge, we just support all four of Ms. Nuncio's requests.
Okay. Mr. Barnett?
We would support them as well.
Okay. Mr. Ralston, before I go to you, let's, there's a standard presence instruction.
I don't have any problem with mere presence.
Okay. Anybody know the number off the top of their head? It's only the defense, right? Eight point five?
We're pulling them up now, Your Honor.
Yeah, I think it's 8.5.
Yeah.
Mr. Wilson, you don't object to 8.5 being given?
All correct.
Okay, and so, I guess on initial reading, the court would propose leaving it written as is rather than trying to differentiate between the defendants, because I'd be concerned that it would create more of a focus on them than is intended by the instruction.
We would agree with that.
Mr. Shagger?
We've taken a position.
Okay, Mr. Barnett?
Just reiterating, so.
And Mr. Ralston, any objection to the standard language?
No, sir.
Okay.
Judge, I'm sorry, we agree with just using defendants.
Okay, I think for the other three, what I'd like the attorneys to do is get together on some proposed language, so that way Mr. Ralston knows what we're talking about in terms of whether he agrees, and then that way I know what we're talking about in terms of what we're looking at. So let's take a couple of minutes to do that. And then once it's done and you get a chance to review it, just let me know and we'll come back and talk about it, okay?
Very well, thank you.
Okay.